just want to be appreciative of everyone's time, so we will go ahead and kick off, even though some people are coming. I know they're underway, but we're almost 15 minutes in, so, all right. So welcome, everybody. I'm really grateful that you're all here on a Saturday, put in the work to get the education you need to move forward and do what the citizens ask you to do with 115. I especially want to thank the training committee. The co-chairs aren't here right now for supporting a very rigorous schedule to get you the foundational knowledge you need over the next couple months. And that would be Alana and Kyle and the training committee's work, who got us here and approved the training schedule for you and kept things moving forward. All right. And then I want to also thank Delonte Spencer Thomas, who will probably be joining us from City Law, who also helped to make sure that we were able to get our guests here on the schedule that we wanted. And he did some expeditious work at City Hall to make that happen. So without further delay, I want to introduce you the Dean of CSU's School of Law, Lee Fisher, who is also a past commissioner for 4 years, right? Yeah, 4 years. So he was in one of the first group, 2015, and so he was one of the inaugural commissioners. So,
okay, well, thank you very much. First of all, thank you very much for inviting all of us to be with you today. I want to do some quick introductions based upon what you see up here. Today you're going to be hearing from 3 of my colleagues and friends. Stephen Chen, Stephen Chen, who's an assistant professor at our law school, former research social scientist at the American Bar Foundation, and a lecturer at the Academy for the Judiciary and Ministry of Justice in Taiwan. You're also going to be hearing today from Kalita Sim Jackson, who's the director of our Pardon, Clemency, and Reentry Clinic. She's also a former attorney with the Federal Public Defender's Office and the Cuyahoga County Public Defender's Office. You're going to hear from Bob Triazzi, who is a clinical professor at our law school, former Cleveland Municipal Court judge, former Cleveland law director, former Cuyahoga County law director. And you're going to be hearing from Jonathan Whitmer-Rich, who is our senior professor of criminal law. He's also the associate dean, so he helps me run the law school. And Jonathan's a former attorney with the Federal Public Defender's Office. And as Jason said, I served as a commissioner, and I also had the privilege of being in elected public office for 18 years as Attorney General, Lieutenant Governor, State Senator, and State Representative. Before I launch into the slides, I just want to say a little bit about my time as a commissioner. And that is, I was telling Jason, if I could trade places and be a commissioner now, as opposed to when I was, I would like to be a commissioner now. The first couple years were rough, particularly the first 2 years. We had no budget, no staff, and basically no directions. We had to sort of make it up as we went. And it was frustrating, to say the least. There was also tension and friction between some of the members. Some members felt that they were there for one reason and one reason only, and that was to be anti-police. There were others who were there to, like Steve Loomis of Patrolmen's Association, to be defenders of the police. And I think sometimes some of our members forgot the mission, and it was to be neither. It was to actually focus on how we improve the relationships between the community and the police for the betterment of all. Some commissioners grandstanded to the audience, and that was unfortunate. Every commissioner, without exception, was there for the right reason and the right motives, but it didn't work too well for the first 2 years. And if you Google YouTube Lee Fisher reflections, you'll see that I gave some reflections after my first 2 years as a commissioner. It's on YouTube. Each of us who were the charter members were asked at a community policing meeting to actually give our reflections about what the first 2 years were like. And so I went through some of that. I was a little more tactful than I'm being right now. But bottom line is that I admire what each of you were doing. Oh, by the way, we also did it for free. We had no compensation and no reimbursement of expenses. So I'm just asking you to feel sorry for me. That's all I'm asking you to do. Okay? I'm just looking for a little sympathy. That's all I'm asking.
We'll give it to you.
It's not like you make a lot of money, by the way. I'm well aware of that. But already based upon my conversation with Jason, this is a much more professional group where I think you better understand than I think we did what your mission is. And so I salute you for doing what you're doing. I'm going to challenge you a little bit this morning, and my presentation will be very different from my colleagues. They're going to be focusing on the law. I'm going to be focusing on your mission. And I also want to apologize that I have to run right after this because this weekend is Admitted Students Weekend, where we try to convince the students who've been admitted, who have more than one choice of law school, to come to our law school. And I'm giving the welcome at 10 o'clock. So I think I have more slides than anybody else, but the shortest presentation, which means I have to move fast. Okay? So I'm a big believer that anything you do in life, you begin with the question, why? Why am I doing this? What's the whole purpose? And so I'm going to ask you to sort of take a big picture of what you're doing today and ask yourself what your mission is. I looked online and I saw that if I could summarize the mission of the Cleveland Police Department, it's basically they say they want to be the guardians of the community. And if I looked at your mission, it said you want to bring community voices to policing. Both of those are worthwhile missions. But I want to ask you to think about restating your mission at some point. Not that you don't have a lot of work to do already, because I think your mission is a little bit different. I think it's bigger than all that. And it goes back to the why. So I had a professor, a torts professor in law school, who said something that I have never forgotten. And it's sort of been a watchword of mine during my years, particularly when I was in public office. He said, it's better to have a fence at the top of the cliff than to have an ambulance below. But if you think about it, most of the things we do in public policy and in life are focused on down here. Cleaning up the mess, punishing people, holding them accountable, all of which, by the way, is necessary. You have to have both. But we spend very little time with the fence at the top of the cliff trying to prevent everything from happening. And so my view is that your mission is primarily to be the fence at the top of the cliff. Sometimes, though, we get confused and think, no, our job is really to punish those police who do bad things and to hold them accountable. Yes, that is part of your mission. But that shouldn't be the focus. The focus should be prevent that you ever have to be in that position and build the fence at the top of the cliff. So that's basically the premise of my next couple slides, that I would like you to always be thinking about, are you being the fence at the top of the cliff and looking at the bigger picture? So here's what I think your mission should be. I think your mission should be to instill hope, restore faith, and build trust. It's not really different than what you're doing. It's just a different way of looking at it and a different way of stating it. When I say build hope, I mean build hope in the community for people who have lost hope in their own future and in their ability to deal with the police. To restore faith because many people are cynical that this will ever be solved. That police reform is just some sort of tangential, distant objective that we all want to strive for, but none of us really think it'll ever happen. And then build trust. And that's the most important one. Ultimately, your job, all of our job, is to restore trust in the community, between each other and with the police, and with the police with each other. In other words, trust is sort of the glue that keeps society together. And trust is completely broken down between police and the community. And so let me explore each of these concepts very quickly. Let's first talk about instilling hope. Some of you may know my brother-in-law, Matthew Zone, who was a Cleveland City Councilman for 20 years. I'm married to Peggy Zone Fisher. Mike and Mary Zone had 9 children. Mike was in Cleveland City Council for 14 years and then died of a sudden heart attack. And then Mary was appointed to fill a seat, and she served for another 7 years. So they served for 21 years. Matt served for 20 years. So on the near west side of Cleveland, known as the Detroit Shoreway area or Gordon Square, the Zone family has represented that community for more than 40 years. And the story is that they got married in December of 1944. And Mike is in his Army uniform because literally days after they got married, he went out to fight in World War II. And in December of that same year they got married, he got captured as a prisoner of war in the Battle of the Bulge. And Mary thought all those dreams of the grocery store they were going to start at 65th in Detroit, and the 9 children they were going to have, they didn't know that was 9, but they knew there was going to be a lot. And a lot of children they would have, that dream was gone. She thought she'd never see Mike again. Well, we always wondered how Mike Zone survived when younger men and smarter men and stronger men did not. One day, when Peggy and I decided to write a book about her remarkable parents, Mike had already passed away. And Mary pulled out of the closet something she had never shown any of her 9 children. And that was the diary that Mike Zone kept as a prisoner of war. To this day, it's legible. There's a copy in the Western Reserve Historical Society. And that book tells the story of how he survived. And it's really pretty amazing. This is just an excerpt of that diary. Wow. But there are 2 things that jump out of this diary. Number 1, he named the 9 children they would have. Every single one, he knew what their name was going to be.
Have you already written this book?
Huh?
Have you written this book already?
I haven't written this book, no.
Okay, I want to read it.
But no, I didn't write the book. Oh, the book. Oh, yeah. I did write the book. Yeah. Yes, I did, yeah. But when I say I wrote it, you know what we did? We interviewed Mary Zone, and then we edited it. So it's really Mary Zone speaking about her life. It's called My Way, after the Frank Sinatra song. And by the way, you can't get it at Barnes & Noble. You can only get it from me and Peggy. Okay, so we'll loan it to you, okay? It wasn't like a bestseller. But although it could have been, I guess. I should have thought of that, yeah. Anyway, they talked about the 9 children they would have, one of whom would be my wife, Peggy Zone Fisher. But the more interesting thing was that throughout this diary were intricate pasta recipes. The Zones are Italian, and he loved to eat pasta. He had no idea how to cook it, but he wrote recipes. He wrote recipes that were so good and so exquisite that when he was finally liberated the following year in the spring, came back and showed Mary these recipes. He didn't even understand what he had written, but she used them and she said, these are pretty good. And she was a great cook. So how did he survive? Here's how he survived. He could see beyond the cruelty of the guards. He could see beyond the barbed wire. What he could see was his future. That was his hope. That's what kept him alive. And it's the most powerful emotion in the world. There's a book by Viktor Frankl, thank you. Search for Meaning, thank you. And that is all the premise of the whole book. And so when I served as Attorney General, I went to all of Ohio's prisons. And I met young men and women who had no hope. They came from neighborhoods that were tougher than the prisons they were in. And for them, they didn't think too much about whether they were going to be going to college or law school or what career they were looking for. They were thinking about, how do I survive next week and next month and maybe next year? They had no hope. And so I have come to believe during the career that I've had, both in the public sector, the nonprofit sector, the private sector, and now the academic sector, is that the greatest gift you can give any human being, is the ability in those toughest moments of their life to see their own future. If the people in our community right now who are not being served well, often by our police, had more hope, had more ability to see their future, the chances that they would actually be even in danger of violating the law would go down close to 0. So part of what we need to be doing, I think you need to be doing as a commission, is thinking about that piece. How do we make sure that we're a fence at the top of the cliff and find ways to instill hope in a community that has lost hope? And so that's what I mean by instilling hope. The other thing I would say to you is about faith. And the reason faith is so important, and I'm not talking about religious faith. I'm talking about optimism, the ability to feel like no matter how bad things are going to get better. So the story I want to tell you here is Admiral James Stockdale, the longest serving prisoner of war in the Vietnam War. Far longer than my father-in-law was ever a prisoner of war. And when he finally was freed many, many years after he had served as a prisoner of war, people said to him, how did you survive when younger men and stronger men and healthier men did not? And he said something that's become known in leadership jargon as the Stockdale paradox. And here's how it goes. He said that there were some of the prisoners who were absolutely convinced that they would never, ever be liberated, that America had forgotten them. And they died of broken hearts because they had lost hope almost from the day they were in the Hanoi Hilton, which was the prisoner of war camp in Vietnam. He said there were another group of prisoners who were eternal optimists. They thought that they would be liberated by Christmas. Christmas came and go and nothing happened. Then they thought, well, we'll be liberated by Easter. Easter would come and go. We'll be liberated by Memorial Day. And you get the point. Every time they thought they were going to be saved, they weren't. They died of broken hearts too, because they were the optimists. And then there was a third group led by Admiral Stockdale. And he said, look, we're not going to be liberated by Christmas, by Easter, by Memorial Day. We're probably not even going to be liberated anytime this year. But here's the deal, guys. We will be liberated. I am positive. I have an irrevocable belief that we will be liberated. Don't lose your faith. He is what I would call a realistic optimist. He believed that there was a solution. And so I say to you, and particularly many people in the community with whom you deal with all the day who say, this is all a farce, this is all a facade, this all looks good, but this is never really going to change anything. I think what you say to them is, you know what, you're right. Short term, it probably won't. But long term, we all have to have the faith that we actually can do this, that we can become the fence at the top of the cliff. So that's what I mean when I say never lose faith. Be realistic optimists, but be optimists. And then the third and final part of your mission is in many ways, I think, the single most important, and that is trust. I am a big believer that change happens at the speed of trust. In other words, it's the single most important thing to affect change, no matter what it is. You have to establish a base and a foundation of trust, or it just falls apart, no matter how noble your motives are. So it's no secret, America, other than the Civil War, probably has never been more divided than it has been over these last maybe 5 to 10 years. And we all know that we are shouting at each other and talking past each other. I don't mean the people in this room, but all you have to do is turn on the TV and you see what I mean. And it's because we are so focused on trying to get our argument bought, that we are so focused on trying to convince others that we are right, that we don't even take a millisecond to think about whether or not the person with whom we are arguing might have some points too that are right. It is why most divorces occur. It's why most wars start. One country not listening to each other, one spouse not listening to each other, is the single biggest problem in America today, and why we have so much political division. And I would argue the major reason why we have problems between the police and our community, because they're talking past each other and not with each other. And so I think that if we can stop putting our heads in the sand, stop putting our fingers in our ears, and do something that Stephen Covey talked about. Stephen Covey wrote this book that is my favorite leadership book. It's called The 7 Habits of Highly Effective People. And I admit, I don't always remember all 7 habits, but there's one habit that is stuck in my brain ever since I read that book, and I've never forgotten it. And it's a pretty simple one. He said this. Oh, that's not what he said. I forgot I had this slide. This is from To Kill a Mockingbird that says, people generally see what they look for and hear what they listen for.
Exactly.
Right? In other words, if you're conservative, you watch Fox News. If you're liberal or progressive, you watch MSNBC. If you're somewhere in the middle, you watch CNN. But we're all looking to confirm our own beliefs. We're not taking the time to watch Fox News if we're liberal, or MSNBC if we're conservatives. Why would we do that? That'll just get us angry. So we just listen to the things that confirm, and because of the algorithms of Facebook and Instagram and everything else, everything that comes to us simply confirms that we're right? Because that's what we hear every day. So that's what that point is here. But getting back to Stephen Covey, here is one of his most important habits of effective people, and that is seek first to understand, and only then to be understood. Most of us, including me, spend most of our life trying to be understood. Understand me. Understand who I am. Understand where I come from. Listen to my argument. Here's why I'm right. And we spend very little time thinking to understand the other person. If the police in our community were trained to instantly think first about what is that person in the community thinking, that young woman or man who's angry at me right now, why are they angry? It probably has nothing to do with you, policeman. It has to do with their life. It has to do that they maybe don't feel any hope. And community person, when you see that policeman who you think is unfair, is brutal, and is about to unfairly arrest you, think about what's going on in their life. Why did they take this job? Most of them took this job to make you feel safe and to make you safe. Not all of them, but most of them. In other words, if somehow we can get the community to better understand the motives of the police and the police to better understand who the people are they serve, we got a chance at establishing trust. And that's the only way we can do it. So I would argue that your mission is to do what Steve Jobs said. Steve Jobs was once asked, if you could write your resume in only a couple words, what would it be? And here's what Steve Jobs said: I tear down walls, I build bridges, I light fires. If we can tear down the walls between the police and the community, if we can build bridges between them and light fires of hope and trust and faith, then that's your mission. That's how we solve this. Is it easy? Of course not. And the devil's in the details. I know that. But I just ask you once in a while to take a few steps back, a deep breath, and think about why we're doing this and what our mission is before you delve into the details, because most of our lives, we deal with the trees, not the forest. We don't take a look at the big picture. We're just dealing with that stuff that's in our inbox, or the thing that's we just heard about yesterday that we got to solve, and we're the ambulance at the bottom of the cliff. And so the extent that you can be guardians, but different kinds of guardians, I challenge you that your mission and your identity is this: you are guardians of hope, faith, and trust. That's the end of my talk. Okay. So now you're going to get into the law. Isn't that exciting? Okay.
Are you ready for us to reach out to you?
Yes, absolutely. I'll give you my email address right now. It's Lee Fisher, and it's lee.fisher, Fisher, no C, Lee.Fisher, Fisher, at csuohio.edu. And I'd be honored to talk to any of you, although I want to say to you, I'm not pretending I know anything more than you do. I'm just giving you perspective, having been a commissioner in public office. And when I was Attorney General, I dealt with law enforcement every single day, because I was not only the chief legal officer of the state, I was the chief law enforcement officer of the state. So I just come with a different perspective, having dealt with different perspective. Yes.
What was the name of the YouTube video where you say you gave your perspective?
You know, I don't know what the name of the video is, but I know if you put in Lee Fisher, Cleveland Police Commission, Reflections, YouTube, I think those are the 4 words you got. Those 4 that you got to put, it'll come up. Because I had forgotten about it last night when I was thinking about it. I put those words in and I watched it again because I haven't even seen it since I did it, and it was 2018. And I just talked about, I didn't get into I talked a little bit about trust, but mainly I talked about the struggles of the commission in the first 2 years and how it was beginning to turn around. But it wasn't until Jason and his team came on board that actually we saw light at the end of the tunnel. We needed staff. We needed professional staff and support. And Jason's coming on actually was the turning point in the life of this commission. So I give Jason and his team a great deal of credit, because it wasn't very much fun before the staff came on board. So now I introduce to you, or reintroduce to you, Professor and Associate Dean Jonathan Rich, who is also the co-chair along with Professor Triazzi of our Criminal Justice Center. I apologize that I have to run to go to convince admitted students that they should come to our law school. Thanks, everybody.
Thank you.
Okay, thank you.
Okay, thanks, everybody. We're delighted to be here with you this morning, and as Lee said, the devil's in the details, and that's what we're going to do for the next 3.5 hours, right? The details. So we're here until 1 o'clock. Maybe we can stay a little bit after that if need be. We have a lot of topics that we can cover, and we'll see if we get through them all or not. So I'm going to give you a really brief run through of everything we hope to cover. We might not get to it all. We're going to try to present on each topic briefly. We'll kind of take turns presenting. And so they're not going to be super long presentations. At the end of each brief presentation, we'll have time for you all to ask questions. At times throughout, we'll have a few kind of scenarios or examples that we can discuss as a group of like, what do we all think about this? How does it fit in with the rules we just talked about? So real quick overview. I'm going to give a brief description of the consent decree and the creation of the original CPC. That'll be brief. We'll hear a little bit about your powers, the powers of the newly constituted Community Police Commission. A little introduction into the overview of what are the sets of legal rules that govern the police, and what do we think about in terms of compliance? How do police, thinking about police compliance with those rules. A brief intro into the topic of policing and bias. We'll talk about the Fourth Amendment. The Fourth Amendment is the key constitutional provision that governs the police in the United States. I'll talk a little bit about the First Amendment, another important topic, obviously. We'll go into some specific issues like police and prosecutor obligation to disclose certain information in a criminal prosecution. Remedies for police misconduct, issues relating to when the police are being investigated and they are asked to make statements. There are some complicated legal issues there. Questions of sovereign immunity and qualified immunity. You probably heard the phrase qualified immunity out there. We'll talk about that a little bit. Explain a little bit about subpoenas. I believe that you all, as a commission, have a subpoena power, which is an important and remarkable power that you have. And a little bit about public hearings. So that's the big picture overview. That's it. We're going to get rolling. And like I said, we'll try to keep our presentations brief so that we have some time for Q&A and discussion as we go forward.
Would it be possible to get a copy of the slide?
Yes, I would be happy to send a copy of the slideshow. Or Jason already has a copy of the slideshow, and he's welcome to share it with the commission. Absolutely. So you don't have to write everything down. There will be a quiz at the end. Okay, so some of you, I'm going to keep this quick. Some of you know this. Title 42, United States Code, Section 1414, federal statute that gives the Department of Justice the authority to file a civil lawsuit against a local police department or municipality to eliminate a, quote, pattern or practice of constitutional violations. And so in 2014, the Department of Justice had been conducting an investigation into the Cleveland Division of Police, and they issued a report in December of 2014 finding that the CDP engages in a pattern or practice of the use of excessive force in violation of the Fourth Amendment of the United States Constitution. Quote, we have determined that structural and systemic deficiencies and practices, including insufficient accountability, inadequate training, ineffective policies, and inadequate engagement with the community contribute to the use of unreasonable force. So that's the DOJ's perspective, right? It's not necessarily the CDP's perspective. They filed a lawsuit in federal court, and that lawsuit was resolved by a consent decree that was agreed to by all the parties, the city and the Department of Justice, in May of 2015. And the consent decree you may have looked at, it's very long and detailed. There's about 105 pages long. It has a lot of stuff in there. It creates the monitoring team, and it created the original Community Police Commission. And that document, that was an advisory body, right? It kind of issued recommendations, could issue reports, but didn't have a lot of actual powers, okay? You all have some actual powers, as I understand it, right? Okay, and so that's on to our second topic. A brief overview now of the powers that you all have, the powers of this Community Police Commission.
Hello, everyone. Morning. Lee started his remarks out by focusing on the question of why. When it comes to issues of municipal law and identifying powers, and any municipal lawyer will always, the first question to ask is, what is your authority and where does it come from? I mean, because everything that you do is rooted in some governing document, some governing body. Typically, like from my experience in the judicial system, I mean, we have an entire court system. Our common pleas court system is a constitutional court, so the authority at that level comes from the Ohio Constitution. I served on the municipal court, and the authority for municipal courts come from the legislature. So there are different sources of authority. The authority, so the asking the question, like, where does your authority, where is your power rooted? Where does it come from? It is from the charter. This is not a legislative enactment. This is a charter, which is more of a constitutional. You're in the constitutional arena here, and looking as you analyze the charter is unlike other charter commissions, like say the Civil Service Commission, which is a very orderly a recitation of what the powers are and how you go about exercising those powers. These charter provisions cover a lot of different areas of what the mission of this commission is. And one way of looking at it is like from a true power standpoint, what is the decision-making authority? All right. So there are aspects of the chart and your responsibility that are clearly identified as with the level of authority that you have. It's really termed as final authority. This is your work in a decision-making capacity. So much more of the charter is an outline of what I think you can frame more as the breadth and depth of your responsibilities, the types of things that you can engage in. So I mean, there's a whole laundry list of them. You review, audit, verify, training, interview, recommend candidates for commander, establish bias screening, bias training. These are things that aren't rooted in decisions, but in responsibilities that you have to meet your mission. Engage in community outreach, maintain connection and collaboration with disenfranchised communities, provide technical assistance, publish and distribute information. These fall within this overall responsibility that you have, but your power comes within the decision making authority that is outlined in the charter. The power to review, approve, and modify discipline. All right, so this is a power that up until this charter provision was a power of the that rested within the police chief under the charter. You have the power. You have decisions to modify, review, approve, and modify policies with regard to applications and examination and training, which is a power before your power, rested within the Civil Service Commission exclusively. Now you have a power that supersedes. You have the final authority, the final decision making with regard to that power. And then similarly, with regard to the police policies, procedures, and training regimens, again, before this charter provision, that rested within the Department of Public Safety. All right. So these are the powers that you have. Other sources of powers that have not been touched upon, possibly down the road, is whether there is any powers that the council could provide you. That's all to be determined whether or not there's going to be in terms of to expand your power in any other direction. That can be done legislatively as well as through a charter amendment. And in terms of not defining your power, but in the exercise of your power, oftentimes how you exercise your power is clearly defined within the charter. That is not, when you review these charter provisions, there's not a lot of guidance here as to how do you exercise your power, except for, as Jonathan already alluded to, the power of subpoena. That is a power. The power that you have in rulemaking, the power that you have in accessibility and mandated cooperation and fast tracking public records. These are the powers that appear within the charter. But what is not clear in terms of the exercise of any of your decision-making powers is what the standards you need to comply with. I mean, because part of when it comes to decision-making, you are the final authority, and legally, you're the final authority within the decision-making process. Within the municipal corporation, within the city, you're not the final authority on the matter, though. Everything that you do when you're making the decisions is subject to review. All right, and so the challenge going forward is developing, probably through your rulemaking authority that the charter grants you, the rules of the game here. What standards do you apply? Like, for instance, the charter is very clear when the police chief reviews a disciplinary decision. It specifies in the charter that the review is based on a clear and convincing standard. The chief has to be convinced at a legal standard here in order to change what the decision previously was. There's no delineation of what your standard is. And perhaps through the rulemaking authority that you have is how you come to that. How do you hold yourself? What are the rules that you're going to apply to exercise the authority that the charter has given you, and to be able to clearly delineate? Because when your decisions get reviewed, that's the standard that you need to meet. What is it from a review standpoint of your power? You need to guard against an assertion that it's arbitrary. That's what from a court kind of reviewing the exercise of your authority. That's the standard. That's what they're going to be looking at. And so, how do you put forward? What is the standard that you're going to apply? So then when somebody is, a court is reviewing the work, that you've met that standard, and that's work to be done now. As to how you use your rulemaking authority to make sure that you have a process in place, you have standards in place. Again, the charter is silent on those with regard to how you exercise it. You've got tools through the charter, but it's silent as to the standards in which you need to apply.
Okay, we're going to keep rolling a little bit longer before we pause for questions. Stephen is going to come up and give an overview of the legal rules governing the police. A kind of brief introduction. We'll go into more detail on some of this later, but he'll at least start us out.
Hello everyone, good morning. I'm Stephen Chen. It's really lovely to be here today. So I'm going to briefly, I'm going to sit here. Okay, good, perfect. So I'm going to briefly talk about the regulation structure that governs police behavior. And this is what I like the most about the law here in the US. So I train Taiwanese prosecutors, I train Taiwanese lawyers and police. And this is very different. When I was in California, I worked for the district attorney's office. I also trained the police there. And this is somewhat a little bit confusing because in most of the countries in the world, there's only one single regulation that governs police behavior. But that's not the case here in the United States. In the US, it's extremely sophisticated. You can think of that as a pyramid. The US Constitution, especially the Fourth Amendment, the Fifth Amendment, and the Sixth Amendment is the foundation that governs police behavior. But there's a lot of questions that is irrelevant to the Constitution, and it requires other set of regulations
to fill in. And sometimes they will see things quite differently. For instance, we will talk more about that later. Under the Fourth Amendment, it doesn't matter what police are motivated, meaning that motivation is irrelevant for our Constitution, for the Fourth Amendment search and seizure. So that means police can stop you for traffic violation, even though they are motivated by whatever reason. That is not going to be considered by the Fourth Amendment. However, that doesn't mean other regulation will say that is okay. Okay, that's the one key concept. So, Fourth Amendment or the Constitution is the minimum protection. All of these regulations are building a wider net for us to govern police behavior. Okay. So, for instance, let's take a look. We have other federal law, we have Constitution, we have state legislation. Let me give you one example. Under the Fourth Amendment, the Constitution, the police doesn't need to have any reason to knock on your door and say, I want to talk to you. That is okay. Okay, the police can just walk on the street and knock on the door and say, I have no reason, but I just want to have a lovely chat with you. That is okay. However, in some states' constitution, it says that no, you need to at least have some reason, a very low boundary, but you need to at least be able to articulate the reason why you want to knock on that door. So now you can see the difference. The Constitution doesn't care, but there are other regulations like state constitution. They are more active. They can regulate that, and that is okay. So we have to pay attention to what the Ohio Constitution said about it. That's the second concept. Another thing I think really interesting, and I think the state law is more active in regulating this arena, is police interrogation. The Constitution said nothing about whether or not you need to video or audio record the interview or interrogation. But many states, their constitution or their state law, like here in Ohio, I believe, already required that under circumstances like juvenile or certain crime, the police need to video or audio record the interrogation. Now you see the difference, okay? And there are more states that are more active in regulating police behavior that goes beyond the Fourth Amendment protection. But there are other states, I think Ohio is less active in this perspective. Ohio, there's not a lot of differences, meaning that if you are the police officers and you want to understand what I can do, what I cannot do, the major source is still the Constitution, the Fourth Amendment, Fifth Amendment. Okay. By the way, any clarifying questions? Oh, yeah.
How is the hierarchy of like mandated statutes organized? So, for example, if the Fourth Amendment says one thing and the Ohio Constitution says another thing, how is that clarified?
Okay. Yeah. So the only way that the difference is okay is that the state is offering more protection. The Constitution is the minimum protection. The state can go beyond that, but cannot go beneath that. Okay? Good. That's a good question. And oh, yes, please.
When you mentioned with the Fourth Amendment that, I'm sorry. When you mentioned with the Fourth Amendment that like the police could still stop and interrogate you and they have questions, is that like an example of them having or needing to have some type of reasoning?
Okay, and we're going to talk about the concept from probable cause to reasonable suspicions to merely hunch. We're going to talk about that concept. But here, I just want to say that there are some concepts that is based in Constitution, particularly Fourth Amendment. And the idea of probable cause is based on the Fourth Amendment. The idea of RAS, we call it reasonable articulable suspicion, is also based on the Supreme Court's interpretation of the Fourth Amendment. Those are the Constitution. But there are other concepts that you need to look beyond the US Constitution. Another example is Okay, if you are being interrogated, what should police do before they interrogate you? We all know the famous Miranda, right? Okay, that is a 1966 Supreme Court case. After that case, every state will have to do the same thing. The police, no matter where you are in this country, have to give a Miranda warning. But let me tell you this, before 1966, almost half of the state already have some regulation. It can be based on state law or office policy, especially on the federal level, that ask the police to provide Miranda warning. So the US Supreme Court's decision doesn't affect those jurisdictions that already have it. But if you have a US Supreme Court's decision, that means every police in this country will have to meet that minimum standard. That's the logic here. Another recent example is your cell phone. What if the police want to get the cell site location information? Okay, the US Supreme Court have a ruling in Carpenter, I think it's a 2013 or 14 cases. It says that you need to get a warrant. I used to work in California, and in California, we actually have a state law that already asks the police to get a warrant to get those cell site information data. So that means if you are a police officer and you practice law in California, that Supreme Court decision will not change your behavior. But there are other states where the Supreme Court decisions will change your behavior dramatically. And that's my final point about office policy. Yes.
So when there is that, a higher law of the land regulation gets made or ruling gets made, does that, if another state already has the same concept, but maybe the wording is different or it's a little bit different in practice, do they have to change the practice?
It's a really good question. A lot of the time, like I'm still new to Ohio. I used to work in California and then Chicago. So Ohio law is new for me. But based on my observation, a lot of the time, our judges in this state is trying to meet the standard of the U.S. Constitution to what the Supreme Court said. So if there's any areas that needs clarification, they will look at what the U.S. Supreme Court justice said. So try to sort of let the two standards meet each other. That's one way that they will interpret the Ohio law. Yes.
I'm going to make a commitment to everyone. I'm not going to get too excited and ask too many questions. Professor, can you please define the rights guaranteed from the 4th, 5th, and 6th Amendments for the group so we could have mutual understanding? And then can you also briefly overview the context of the first 10 amendments of the Constitution and why we have them?
And that's what we are going to do for the next 3 hours. And here is just an overview. So let you know that there's 4th Amendment, there's 5th Amendment, there's 6th Amendment. So basically, just a quick overview. The 4th Amendment is governing search and seizure, what the police can do to search you, to arrest you. That's the 4th Amendment. The 5th Amendment is about interrogating you. Okay, what kind of information they can get from you. The 6th Amendment is about your right to counsel. That's just the basic idea. We will get into that. So my final point is about office policy. Office policy matters because that is the place where the police officers will read. They are not going to read Supreme Court decisions. They're not going to, go to Westlaw or Lexis and pull out those case law. No, they relied heavily on office policy. That's their major source of information. So always look at that and see if there's any mistakes. If there's a mistake, the officers will follow, not the U.S. Constitution, but their office policy. Okay? And there are areas where the office policy and those instructions matters more. Because, for instance, in California, when we talk about the 5th Amendment, we talk about a few case law. It's about 5 to 6 major cases. But the manual that we use to train prosecutors and police is about 900 pages long. So you can see the difference. Officers relied on those instructions to build their legal knowledge. So it matters a lot. And there are areas where office policies will shape the contour of the 4th Amendment For instance, if your car got impounded, police under the Fourth Amendment, they can search your car entirely, but it has to be based on office policy. If the office policy sets the scope, you need to follow that. So in that arena, your office policy will shape the scope of the Fourth Amendment. Okay? That's one example. Yeah. Yes.
Just to clarify, when you say office policy, you mean like local department policy?
Department policy. They need to issue a written policy that tells the officer, this is what you can search if there's a vehicle being impounded. We call this inventory search. So Supreme Court left that question open to the local police department to define that policy. Otherwise, the policy is a reaction to what the Supreme Court said, to what those justices interpret the U.S. Constitution. Okay, that's the overview. Thank you.
Thank you.
Okay, excellent. Bob is going to come and talk a little bit about the concept of police compliance with law and procedure. I just want to make one comment quick, interplay of policy and constitutional rules. One thing that you might hear, and that I have heard in the past when working with the police commission is, I was part of a group that was working on the search and seizure policy, and we might suggest, we think Cleveland Division of Police, it would be a good idea for your policy to require this. Sometimes the answer would be, okay, but the Fourth Amendment does not require that. And so sometimes there's a resistance to change policy on the ground that, well, the U.S. Supreme Court has already decided this under the Fourth Amendment. And that argument is a mistake, right? It doesn't mean that we should adopt that new policy, but the Supreme Court under the Fourth Amendment has repeatedly made it very clear. We're setting certain baseline rules on the assumption that individual police departments are going to decide in more detail what they think the rule here should be or not. So the fact that the Fourth Amendment does not require something is not a good reason to say our policy does not have to require that. That's up for you all to have some input in, the police to have some input in, right? So just want to alert you to that basic issue that policy is, it's more detailed. We can expect it to be more detailed than the Fourth Amendment. Okay, very good. So Bob, take it away.
So one way of thinking about the compliance, within the criminal justice system, and this is not exclusive to police work, the criminal justice system is a series, in the exercising authority through every decision, it's an exercise of discretion that brings life to all of this activity. Choices are being made. So there are choices, exercise of discretion at time of arrest, the time of charging, bail, plea bargaining, sentencing, probation violations. These are all exercise of power where choices are being made. And throughout the criminal justice system, there's this tension. There's always, at every level, there's this tension between, the exercise of discretion is rooted in having some flexibility, some discernment, some ability to see some gray and make some judgments. They are on the opposite side is, now how do you constrain that discretion? Now, how do you make things more consistent? How do you make things more equal? So at every level of the criminal justice system, boxes are created. So in my world, as a judge, the legislature severely limited my ability to sentence people, through mandatory minimums, through any minimum or whether something is probationable or not probationable. These are limitations on the power that you have. So within police work, there's a tension of like you want an officer on the street to be able to show some flexibility. On the other hand, then maybe not so much. That you want to have certain standards. So boxes get created at every level. So when you think in terms of compliance, is the box that you want which is the limitations on discretion that you want to create. And that box, as Stephen's already alluded to, is created in any number of places. That box is created, of course, by the constitutional standards, the federal and state constitutions, that limit and outline the parameters of what an officer is able to do, the decisions that get made at the ground level. You have statutory authority, so much of within the city of Cleveland, the Department of Public Safety, all of these things are created by statutes. So in the laws of a community, you have the ability to constrain and define that box through your legislative authority. The other major piece of this, and Stephen already alluded to this, is the rules governing, the orders, the general police orders of the police. That is a very well defined standard that if the police work within the constraints of these orders, that then they are in compliance. They are in compliance with the rules of the game. Piece of this that is also a part of defining the box is your collective bargaining agreements. Because in terms of the law, obviously it's very clear to see where obviously law is the Constitution, law is your legislative authority. Within American law, contract law is like the holy grail, of the legal authority. And so what a lot of times that box is defined by within the collective bargaining agreement. So that's the creation. That's the reasons why you want to make sure that in order to achieve consistency, fairness, equity, that is what this compliance is designed to do. And the real test is the box too constrained, or does the box need to get larger? Is the continuing analysis? Yes.
Can the collective bargaining agreements go against any set of laws, or does it have to, like, if there is a point of disagreement between a collective bargaining agreement and like state or municipal or federal law?
Well, it would be in terms of the Constitution provisions, no. And with regard to legislative authority is maybe. You could always dance around those requirements, but the Constitution is the one that. All right. Okay, Jonathan.
Okay, excellent, thank you. Are you also talking about bias in policing briefly?
Sure.
Is that you or is this me?
No, that was me.
Yeah, great. Yep, go ahead, that's next. You're still on.
Okay, one more quick. In terms of the legal ramification, I know a lot of the charter provisions. I mean, it explicitly talks about training and the need for bias free policing. So that is a mandate. But from the legal standard, I would greatly suggest that everybody, if you haven't already, review the recent investigation of the Louisville Metro Police Department and Louisville Metro Government by the Department of Justice and their Civil Rights Division. Because within that report, it clearly expresses and identifies, what happens when you don't do these things. It is a scathing, it is a sobering. I don't know if anyone have you reviewed that yet? Is that?
Another report.
Yeah, it is, and the bias-free policing is. A lot of it is trying to make sure that you're identifying the right demographic categories. Because this is not just bias and race; it's just across an assortment. Disability falls into this. Gender. They're having policies that in training that are expressly designed to deal with all of the demographic categories is critically important. Here you see, and you'll see this in terms of the Louisville report, that at every level of decision making is where these biases explode. I mean, you really see the ramifications of not having training, not having policies that deal with it. all the way across the board into prosecution and sentence. This is a systems problem. It's not just a police issue. This is across the board. And the other thing to keep and when you look at the Louisville report, you want to focus on this issue from the individual's standpoint. You want your every individual in the police department, in the Department of Public Safety, to be trained in this in terms of their own personal conduct. But the other piece of this that's equally important is how does bias factor into law enforcement strategies themselves? I mean, because a lot of the issues that you have across the country are kind of rooted in a sincere desire to confront, some real serious public safety concerns. So, for instance, one policy would be a recognition that the amount of guns in a community is a public safety hazard. People. This is the connection between the presence of guns and violent criminal activity is real and it's apparent. And so, what was created across the United States, this very aggressive law enforcement strategy about stopping vehicles, trying to identify who's most likely to be out there having weapons, while it was designed to deal with a public safety issue, as a consequence of that, really began to reflect some real policy. Now that wasn't the result of it. It was partly individual officer decision making, but it was part of a law enforcement strategy. All right, so you see a lot of that when from public safety. I mean, a lot of people in the neighborhood would say that they're over policed, but they also say they're underprotected. And this is the challenge for the officers to meet the challenges of underprotection without over policing and policing in a way that demonstrates this level of bias. Yes.
I just had a question about, you mentioned some of the demographic categories. Is class one of the demographic categories, especially considering that it intersects with a lot of the other demographic categories, and also may overlap and may connect them and redouble down on the potential bias a police officer could have against a citizen?
Yeah, under the present general police order, no. All right, but part of, that this is the kind of policy that is not legislated. That this is part of the general police order structure that Stephen alluded to here. All right. So what goes into that general police order, how it defines demographics, it could be an unending list. Right now, it's under our present general police order that is not included, but there's no reason why, if there's a consensus that couldn't be added. Again, this is not a legislative response. This is a management. This is within an internal management component of the police department's authority. What's included in your demographic category? Like, for instance, is behavioral health a demographic? People with mental illness, is it expressly defined? That kind of thing. But your authority is with the training and with the data gathering, and you have charter authority to do both, and to insist on both, and to ensure that takes place, because data gathering informs training then informs individual conduct, and the training then informs the overall organizational strategies. Yes.
Kind of a little bit off the serious question, because I've seen some police, like as I've done research, I've seen some police, I guess, as they're looking at crime statistics, they include socioeconomic data of a community to justify certain police practices. Would that not be considered a part of like demographic information? Because it's not like like it's kind of class, but not really. But they're using like socioeconomic.
I mean, exactly. That is in our society is the root of a lot of bias. Like how your expectations of somebody and their behavior, and they're part of a target group, because they're poor, and because when you look at, if you came into my courtroom any day, you would see that poverty was the greatest defining characteristic of the work that I had to do. And so it's very easy to start drawing some conclusions, and that's those conclusions that you draw that are not rooted in fact, just based on my perception of things. That's what that is.
So we can include that like in a training around bias-free policing. Okay.
Yeah, anything that you think that would create a preconceived notion of someone's, like how they get treated, that's the root of bias, and that would be fair to include that. Okay. All right, Jonathan.
Okay, so now we're going to go kind of deep into the Fourth Amendment. This is going to be a longer section, when we teach this at law school, it takes about 14 weeks, right? So we're going to try to get it down a little tighter than that. But I'm going to give like a very brief intro, and then we're going to cover certain areas, and different of us will come up and talk about different areas. So what does the Fourth Amendment to the U.S. Constitution says? It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The court today focuses very much on this phrase right here, unreasonable searches and seizures. The part about warrants is, of course, very important, but it only applies to warrants. And there are many things that the police do that don't involve warrants. So the fundamental rule that the court talks about is there is a prohibition on unreasonable searches and seizures. You can tell that language is very general. It does not answer all of the questions, right? Can the police look at your cell phone? Well, I don't know. Is that an unreasonable search or seizure or not? There's not an answer from 1780 about that question, okay, right? So the court, has to confront these issues. So we're going to talk about a couple of different issues here. Terry stops. It's on a case called Terry v. Ohio that happened just down on Euclid Avenue back in the 60s. But that's the standard for brief investigative stops by the police. The question of consensual encounters. Oftentimes when the police are interacting with the people in the community, the people think they've been stopped or seized by the police, but the police think, no, we're just having a consensual conversation here, right? The ideas of reasonable suspicion and probable cause, what those mean, a little bit about search warrants, a little bit about exceptions to search warrants, and a little bit about new technology and kind of mass surveillance possibilities. Okay, so Stephen's going to start us out with talking a little bit about degrees of suspicion and probable cause and those sorts of things.
Hi, it's me again. So, big picture. Yeah. So I always like to start with the big picture because this is what many police officers confused about. So think of a situation of a police interaction. It's very dynamic. It's an ongoing interaction. So police can start with almost nothing, but during the encounter, they can gradually develop the degree of suspicion. And during this process, the Constitution will allow them to do more and more. So their behavior can get more intrusive based on the degree of suspicion. Okay? So it matters on how an event starts because it always triggers a chain of event, a chain of action. And we have to pay really close attention to this chain of event because everything is closely connected. If police did something illegal at the beginning, it will taint the subsequent behavior, meaning that if the initial encounter It's unconstitutional that everything that they did after that will be tainted. And we will learn a doctrine called the fruit of poisonous tree. But without getting into detail, the idea is that everything in this chain of event has to be legal so that they can use the evidence that they got from this interaction. Okay, so let's start with hunch. Police just got nothing. Based on their experience, they want to talk to you. Can they do it? Yes, if it is consensual. So many police departments think that consensual stop is actually a good thing because police can build trust, can build relationship with the citizens. People might think differently. So it has to be consensual, meaning that they need to get the agreement from the person being stopped it. So what is the test? The test is pretty straightforward, but the application of the test is complicated. The test is whether a reasonable person, talking about the interactions must be consensual here, a reasonable person feels entitled to terminate the conversation and leave at any time. So we ask whether a reasonable person will do that. What does that mean? Well, that means it is an objective test. It doesn't matter what that person subjectively think. So it's an objective person that we have this imaginary person. And we ask if this imaginary person are free to terminate the conversation and get back to his own business. That's the only test that we have.
What are the things that might trigger a reasonable person, a reasonable objective person to not feel that it's like, if just having your hand on a gun?
Yeah, that's a very good question. I think the question is, what are the factors that could change this dynamic of interaction? That's a good one. So first of all, the threatening presence of many police officers. One, numbers of police officers is always one factor that we look at. Also, display of weapon, another factor. Also, sometimes the court will see if there's some physical touching of the person. Okay, so if there's physical contact between the police and the person being stopped, it could change the interaction from consensual to non-consensual. If that changed the dynamic, what's the question that we need to ask? We need to ask, did you have the degree of suspicions to do the second level interaction? Okay, so touching of the person is another factor. Also, if there's any restriction of the person's freedom of movement. So an example will be, what if you are on the bus? What if there's a bunch of police officers get up to the Greyhound bus? Are you free to leave? Is this consensual? Unfortunately, the Supreme Court got a really interesting case saying that 3 officers get up to the Greyhound bus. The interaction is still consensual. They blocked the entrance, and there's another police officer standing on the back of the Greyhound bus. Under that particular case, Supreme Court said that that's still consensual. You're not being seized, but it's fact specific. I call it fact sensitive. So it's based on all of the information that you have during that interaction. So the presence of the police, whether the police restrict you, is a factor. Also, the manner of questioning, the tone also matters. So here in the Fourth Amendment, we often said that the test is the totality of circumstances test, meaning that we consider everything. And that's where the difficulties comes in when we are trying to draw the line. That's the first level, consensual interaction. Any questions? Yes.
And I'm sorry, I'm jumping ahead. So this is for suspicion of criminal activity.
Criminal activity.
How does this work with people who are mentally distressed? If it's a probate order, how does this change in what they're able to do?
Yeah. Very good question. And I think that's where the Fourth Amendment might not be fully answered, because we ask whether a reasonable person are free to leave or free to make that decisions. There are some cases where the Supreme Court is willing to consider the person's mental status, age, social background. But most of the time, the Fourth Amendment doesn't consider your particular mental status, your age, and other factors, because we only ask what a reasonable person will react to those kind of interaction. That's the basic rules. We might have some exceptions, but a few, very few.
So that means that even with the knowledge of a person's mental status, which a probate order would provide.
It could change the dynamic if the officer knows that.
Mhm.
But in most of the time, the rule is that we only consider a reasonable person without regard to the person's specific mental status.
Is the reasonable person designation given to the officer, since he is the one that has, if the other person is mentally distressed, he would be the one that would be more likely to obey the reasonable person standard, right? So I'm just saying, who holds the responsibility of determining in a situation if one person is mentally maybe distressed or incapacitated, who then is the person that has the responsibility of maintaining this pyramid of activity?
Feel free to jump in. So if I understand correctly, the answer is the judge will have to make that determination. And the test is that judging from everything that is known by the police officer, will a reasonable person feel free to terminate the conversation? So it has to based on what the officer knows under that circumstances. But the test is still objective.
So I don't think it's clear. I don't think it's clear. I think that we've had issues before where there was someone that had a mental health issue. The officer wasn't aware of it.
Yeah.
So as Stephen said, his standard is based off of a reasonable person. So unfortunately, I think there's a gap in understanding that, just to be clear. I
So
don't
when
think
there's a
it
probate
covers
order,
that.
it's clear to the officer. If there's a probate order, it should be clear. If there's a 911 call that says that this was a person that was mentally distressed, that would provide some evidence of pre-knowledge.
Right, if a person's diagnosed, I
Right.
mean, there are plenty of times when someone's not diagnosed, and maybe this is their first thing, so even in the absence of that, it's, in terms of what the officer knows, it's based off of what he's provided. So in the absence of that, I do believe that there's a gap in terms of, so the only basis that he can really act upon is a reasonable person standard. That's why I just.
But you're right that if the police officers know that there's a significant mental health issue going on, for example, this test still, as Steve is talking about, is about whether the interaction with the person is consensual or not. It may be that they know it's not consensual, but maybe they have some other legal, I mean, that's not the only basis on which police can interact with people. They can say, well, I have reasonable suspicion that you're engaged in criminal activity, or I have probable cause that you're engaged in criminal activity. So you might be able to arrest someone even though they're having a mental health crisis based on that, probable cause. So there are different types of legal authorities depending on how much suspicion they have, I guess, is part of the answer.
Is there any cases or precedents? Because when we look at mental health, we normally kind of look at like autism, schizophrenia, things of that nature. But for trauma, for anxiety, so an example would be if I get pulled over, consensual conversation, I get to shaking because I'm traumatized by past experiences. That officer then says I'm under the influence of drugs, right? Is there any cases that have set a precedence for these type of situations when we talk about undefined mental health challenges?
Excellent question. I'm just going to speak for my personal experience where most of my clients have been Black men and they've been pulled over by police and they are nervous. Just kind of setting the stage with that. The officer, in my experience, the officer has used the physical observation of the person in terms of that being reasonable suspicion, like, oh, he was nervous, he was sweating, he wouldn't give me eye contact. So to answer your question in terms of whether the court, whether there's some sort of legal precedent of that being used to inform the officer in terms of this approach, I mean, I would say no, not that I know of. My experience is just been in court and representing people who've had that experience, that it is just lended to the officer to be able to further inquire or to either arrest or to either pursue some sort of investigation regarding any suspected criminal activity.
Yeah, I would agree with that. And I would add that I think this is definitely an area where a lot of us would agree that the U.S. Supreme Court, in setting their vision for what a consensual encounter means, they are not at all sensitive to the realities that you just articulated. So this is an area that you all can think about in terms of, for example, police policy. Should there be policies that state different rules that require the police to consider a person who's pulled over and seems to be nervous? That may be a pretty understandable, expected response, and should not be, without additional specific information, should not be used as a basis to think this person's engaged in criminal activity. That's something to consider as a group, because I think we all agree the Fourth Amendment, U.S. Supreme Court is not very sensitive to that concern.
So I have a question about what then is considered criminal activity, because, we know that there's criminalization of things like mental illness and homelessness, where is loitering considered, criminal activity, or, even charges such as resisting arrest, right? Is there a threshold for what is considered criminal activity? Is it any breach of the law, or,
Okay, that's such a great question. That's where the Fourth Amendment interacts with the state law, because the state essentially defines what is a crime, what is not a crime. Okay, that's one concept. Another concept that will really frustrate you is the Supreme Court said that actually the police can make some mistakes. If they get the law wrong, meaning that if the state law said that this is a traffic violation but can never be stopped or can never carry a jail time, meaning that you shouldn't put this person under arrest. If that's under the state law, good. But the US Constitution doesn't care about that. So that's irrelevant for the Fourth Amendment analysis. So Fourth Amendment doesn't care about police motivation. Police can make certain mistakes. They can get the laws wrong. That's it. And also, the Fourth Amendment also said that even it is a minor crime, like misdemeanor, the police can still arrest you and search you. That's the basic tone of the Fourth Amendment.
Let's continue this by doing an example here, right? And talk a little bit about what you all think of this. So here's a quick example. You and your friend are leaving the store and an alarm goes off. You hear the alarm, and so you start running. A police officer responding to the alarm sees you running. The officer orders you and your friend both to stop, and you do stop. You tell the officer you weren't involved in anything illegal. The officer pats down your clothing and pats down your friend. And so, as I said, right, the Fourth Amendment is concerned with reasonable seizures and searches. So they're two separate concepts, right? You were seized when the police told you to stop, and then you were searched when the police patted you down. So we haven't told you all of the law, and you're not going to be able to learn all of the law, but let's talk about what your reactions are here. What are your thoughts? Sure. So is it reasonable for the police to stop you? And was it reasonable for them to essentially search you under those circumstances? What do you think? That's a remarkably great answer for not being an expert on the Fourth Amendment. Tell me more. Why do you think they can stop you?
Because there's a reasonable suspicion because the alarm's going off. Running.
Yeah.
Microphone.
We need to enroll this man in law school.
That's it? Yes.
I'm sorry. I just said because there is a reasonable suspicion because there is an alarm going off and you're running. However, that doesn't automatically trigger their ability to search you, so they can probably question you. But just being able to question someone doesn't mean that you automatically can search them.
Beautiful.
Wow. That's perfect.
I love it. It's good though. It's good stuff. Well, consider the legal field.
So in this encounter, what the police can do is to stop you and try to confirm or dispel their suspicion.
Right, so as on his chart, right, for a brief investigation, it doesn't mean they can arrest you because they heard an alarm go off and you ran. Doesn't mean they can search you, but brief investigation, ask you a few questions, try to figure out why the alarm went off in the store, a few basic reasonable things like that. Question or comment?
Yes, so I have a similar scenario that I have a question about. When I was when I was in high school, I actually had to learn this for street law.
Yeah.
And the example they always gave us was the fact that high school students are subjected to search and seizures upon entering the building.
Right.
So it's different if I'm in class and I smell something, I smell a certain way, and the teacher's like, "Oh, I think she," or they hear something, they want to search my locker. But just me entering into a school building every single day, I was subject to search and seizure. So our teacher and the lawyers told us that was technically not constitutional. But I'm kind of curious because it was every single student. It wasn't just not the employees. And then our parents were required when they entered the building to give their IDs and had to leave their IDs with security until they left the building.
So I'll touch on that a little bit in a little while, but that's what we would call a quote unquote special needs search. The reason for that search, the school would say, we had reasons that were not criminal law enforcement reasons to do that. So our reason were to try to make sure that guns were not entering the building, keep the building safe. That relates to criminal law, but it's not directly about, we're not stopping you, searching you every day when you come into school because we think you're committing a crime. We're just doing it as a safety measure. And so the US Constitution, the Supreme Court has said, we're going to permit some types of search and seizure without reasonable suspicion or probable cause. They didn't have any suspicion about you when you walked in the building individually, but we're going to allow that if it's a reasonable program. It's designed to serve appropriate administrative non-criminal law purposes like keeping guns out of the school. And we think the program is reasonable, not too intrusive. I'm going to say, for example, that they would not have done a complete full search of your body every morning. Is that true? Maybe they did.
Yeah.
Okay. Well, so that might be like how intrusive that search was is going to be an important factor if that ever came in front of a court as to whether that was reasonable. Having you walk through a metal detector, not super intrusive, probably an effective way to keep a gun out of the school. That's probably okay. A more intrusive search, that's getting more invasive. Is that really necessary? There aren't bright lines here, I guess I would say, but. Okay, great. Yeah, another question.
So I guess to answer the question in a different way, what would it take in that scenario for the officer to be justified in searching and arresting? What would need to happen in that scenario?
Great question. So let's talk about.
Yeah, do you want to talk about the search?
Oh, we can talk about the
Pat down or?
Yeah.
What would it take for them to search you?
Okay.
Good. So let me step back a little bit and talk a little bit about the significance of Terry, that case. For that case, we don't have this concept. This one is blank. We only have consensual interaction or search and seizure. So that means if the police want to stop you, they better have probable cause. But Terry creates a new idea that you don't actually need to have probable cause. All you need is reasonable, articulable suspicion so that they can stop you and have the conversation. So during the conversation, if it's a legitimate Terry stop, they can frisk you. Frisk you is like touching the outer layer of your clothing. They can feel it. So if they feel a small bag in my pocket and they can say that, well, based on my training and experience, this is drug, then what do they have? Now they have probable cause that I have contraband in my pocket. So that changed the interaction from this one to this one. So what does that mean? That means I can be arrested. Now, if I'm being arrested, there's another rule, search incident to arrest. So what does that mean? We will talk about that more. But I just want to let you feel the dynamic of the interaction. they feel that there's a bag in my pocket and they think this is drug. Okay, they can arrest me. After they arrest me, they can now search everywhere, like everywhere. If there's a cigarette box in my pocket, okay, they don't know anything in it. If I'm being arrested, they can open it up. They can search everything that I carry, everything that I have. That's the dynamic.
Yeah, go ahead.
I can.
Okay, that's fine. And to add one other thing, on the reasonable suspicion, they can stop you with reasonable suspicion that maybe you stole something from the store. But to be able to do even the pat down, they need a slightly different kind of reasonable suspicion. They need reasonable suspicion that you have a weapon on you. So one thing that I think police commonly either mistake or maybe, is they sort of think, well, I have reasonable suspicion that maybe this person stole something from a store. That means I can stop them, yes, and I can quickly search them to see if they have it, no. The Fourth Amendment does not actually allow that second type. To do the search, you need probable cause that you're arresting someone, and then you can do the search incident to arrest. So the reasonable suspicion, the pat-down search he was talking about, is very specifically for weapons, and you must have reasonable suspicion that the person has a weapon. So the fact that they were in a store and when the alarm went off, they ran, does not give me any reason to think this person is armed. So they can be stopped, but cannot be searched, right? So a small suspicion that someone has something on them does not allow you to search them unless it's a weapon. You need reasonable suspicion it's a weapon. So that's a very particular rule that's very important and that often gets, I think, mistaken by the police.
And just one quick thing to add about that. So remember, the test is actually armed and dangerous, but in reality, it often mixes into one. If you're armed, you must be dangerous. But Terry actually said it's two standard. The person has to be armed and dangerous.
It appears that for those, because I don't know about everybody else. I've been pulled over and stopped by the police. These processes go hand in hand. So as I play this scenario out in real life time, I'm stopped because I'm suspicious, right? But then I'm also patted down without questioning. And I think that that's where it kind of gets lost in, because we as citizens feel like that, what you just said, those processes go together without just cause. So it's like, I got pulled over immediately, I'm being frisked. Where you been? Where you running from? That kind of thing. You fill a cigarette box, now you think that I might have drugs. So it just continues to escalate without any process or procedure. And so when you say I have, just cause or I have reasonable doubt, the reasonable doubt is because I'm running. I'm in a specific neighborhood. I'm running away from an alarm and I'm black, and I could be white or whatever color, but those processes seem to run hand in hand and congruently. So I think that's something we need to look at as a commission when we talk about these processes and looking in the details. Just wanted to bring
I think so too. So Khalid going to talk about reasonable suspicion and probable cause, correct?
I taught it already.
So let's go into that. Well, we talked about it a little bit, but there's more to say. So let's have you take the floor.
Thank you. And just to add on to what was said earlier, hi, I'm Kalita. Hi. So just to add on what was kind of said earlier, the process does go fast. It's not something that's like, oh, one thing and then the next thing. No, it goes very fast. But we're going to talk about this a little bit more in depth. Again, you all have been hearing about probable cause. You've been hearing about reasonable suspicion. So just going to give you some actual words or the definition along with those phrases. So probable cause, reasonable belief that a crime has been or is being committed and that person, place, or thing is involved in the crime. So an example of this is always, I think of a DUI, because I think this is probably the most common example of probable cause that I've seen, it just at least in my experience. You're pulled over, the officer notices a smell of alcohol on your breath, bloodshot eyes, slurred speech, and delayed response to questions. The officer has probable cause to arrest you for a DUI or OVI. The officer can ask you to get out the car just based off of these indications. Now, mind you, can the smell of alcohol, bloodshot eyes, and slurred speech be indicative of other things? Of course they can. But in terms of whatever the officer's reasonable belief is at the time, he can, as you got the car, can make an arrest. Reasonable suspicion. So something that's just been discussed earlier by Steve and Jonathan, but again, just giving a basic definition. It's a legal standard giving law enforcement the right to briefly detain someone and to pat down their person for weapons. I know I said search, which was wrong, but it's a frisk. It's a frisk. So kind of talking about Terry v. Ohio, the case that happened in downtown Cleveland. Law enforcement officials can briefly detain someone. They have reasonable suspicion that a crime has been committed or is being committed, is about to be committed. So if an officer believes that you are armed and dangerous, kind of what we talked about before, he can stop you, pat you down, can inquire, ask additional questions. What's the difference between the two? So I like food, and I'm going to give you an example of kind of how you give the difference between the two. I don't know, I'm also a visual learner. Probable cause, I would say, is like French dressing. It's thick. It's noticeable. You know exactly what French dressing is, or maybe let's call it ranch. More people like ranch and French dressing. Fair? Okay, so think of it like ranch dressing. It's distinctive. You know what it is when you see it. Reasonable suspicion is like a vinaigrette. Is that, everyone kind of understand what I'm saying? Vinaigrette, you see it on lettuce, you're like, is that vinaigrette? I don't know if it is, but I got to taste it. I kind of got to inquire about it a little bit more to see if it's an actual vinaigrette. Does that make sense? Okay, I'm glad. If it doesn't, let me know. Yes.
For your first example, For your first example, the officer arresting for a DUI, don't they have to do the test first before the arrest?
I mean, typically they do the test, but they can ask you to get out the car depending on the situation. So depending on the circumstances, and I know that's going to be like the lawyer answer, it depends, then they can make an arrest that could be based off of their safety, the person's safety, and then they can ask additional questions, do tests later. Sometimes it could be blood work, depends on the circumstance.
Oh, so they don't have to do that.
It depends on the circumstance. Like for instance, if someone's sleeping on the side of the road and you're talking to them, they're probably not going to be able to do a test. They could call emergency, have blood work done. So there could be other ways to indicate whether there's probable cause for a DUI to make an arrest. It doesn't always have to be the field sobriety test like what we see on TV.
Right, the fundamental test is, do they have probable cause?
Right.
Usually they're gonna do the test because then they know they have it.
Right.
But the machine isn't working or whatever, if they have
Something.
other things that give them probable cause, whatever it is, that's what they can use.
So is this wrong? I was always told that if you get pulled over for your DUI and they ask you to take the test, right? They ask you to blow, that you always decline it and you go back to the police station to wait for your blood alcohol.
Well, for the basis of today, in terms of you right. Well, just for the
Is that wrong?
Well, I don't know if that's fair to answer that question because I'll be giving you legal advice. So just in terms of like what we're here for today and just giving clarity, we can discuss that later. So it's just
Decline creates probable cause.
No.
no.
But they can arrest if you decline the test on their.
If you decline the test and they already have probable cause.
Yeah.
Then they can arrest you. If they don't have probable cause, they can't arrest you just because you just declined.
So if they came up to me and they were like,
Let's just try it out.
yeah.
Right.
You know,
No.
Right.
Always say no.
And remember, just again, the definition of probable cause, reasonable belief that a crime has been or is being committed. So, yeah, so that they need more information. So again, think of ranch dressing, vinaigrette. So enough for a search or an arrest, you know exactly what it is, and they can make that arrest, reasonable suspicion. So not enough for an arrest or a search warrant. May frisk or detain you briefly. Frisk is limited to a pat down for weapons, officer safety, and it's less than probable cause. Ranch, vinaigrette.
So in that scenario of the alarm, the probable cause is established by the proximity of those people to that location and not them running away? Or what
I think that was the reasonable suspicion standard, that the officer was like, there were some articulable facts in terms of that a crime may have been committed, but not sure what it was, so they could have detained that person. For instance, with Terry v. Ohio, the example, some of the facts around that was there were a group of men in front of like a jewelry store, some type of store. And they were walking around, looking in the store, walking around. So I think it was like 12 or some odd, it was a lot of times. So just based off of the conduct, seems suspicious or a little yeah, okay, seemed a little awkward to the police officer, that was enough to detain the person or at least, or stop the person and ask them further questions for that. So I think the alarm was relating
Yeah,
to reasonable
I just
suspicion.
want to clarify, because many people probably, they're not familiar with the law. They think that running away means that you're guilty, or that refusing the test means that you're guilty, right?
Okay.
That would fall more into probable cause.
So, I mean, I would say in the example, it was both, that the alarm went off.
Yeah.
They were near at the time they went off, and that they ran. It's putting all those together, they gave rise to reasonable suspicion.
But not enough to arrest them yet by.
Probably, yeah, not enough to arrest yet, right, not specific enough.
There were other hands raised, I want to make sure. Yes, sir.
My question is, if they can frisk for weapons, it seems like, I guess my question is, like, what constitutes a frisk? Like,
Okay.
I mean, because it just feels to me that like this is like kind of like blurry, because technically I'm frisking you for weapons.
Right.
But then if I find like drugs or if I find something else, now I have probable cause, right? So like, where is the law on that? If they can just frisk, if they're supposed to frisk for weapons, clearly, like you said, if they find something in process, so like it just seems like if I am a particular type of officer and I am suspicious of certain demographics of people,
okay,
I can say I have reasonable suspicion to frisk, but I don't know. I know they're looking for weapons, but it just seems like it opens up so much to but I feel like, how do we know their intent is really to look for a weapon? Right, the likability of someone having a weapon.
I understand your question. We get it. Yes, that was a lot. Do you want to start and I'll finish? That's fine.
So at the beginning of this conversation, I said that the Fourth Amendment doesn't care about intention. So you have to exclude that. And there's actually multiple doctrines at play during that interaction. So remember, when we talk about Fourth Amendment, we talk about multiple authorities that the police can use to justify that encounter. So they can frisk you for weapon. But during this process, if they establish probable cause that there is contraband in your pocket, we are actually using a different doctrine called plain feel or plain touch doctrines. That doctrine says that if you feel something that you think is a contraband, you don't need to get a warrant. You can seize that. So it's a separate authority that allows the cop to go further. That's one idea.
And another part of your question, I think, is these rules constrain the police, but whether an individual police officer is complying with them or really obeying them in a reasonable manner is something that in the first instance is just up to the officer to decide. So they may be saying, I'm frisking you because I think there's reasonable suspicion you have a weapon. And you're sitting there thinking, there's no reason for you to think I have a weapon, but you're frisking me anyway. Well, the cop's going to do what the cop's going to do. And then they find something, they feel something. It feels like that might be a pill bottle. I think you've got crack cocaine in there. Okay, pull it out. Oh, it was just this. You think the police did not have probable cause to go in there and search my pocket because they just felt it. It doesn't feel like anything. But the cop said, no, I did, whatever. In the instance, the cop is going to do what the cop is going to do. If you get charged with a crime, then a judge is going to evaluate some point later, 5 months later, a year later, did they actually have reasonable suspicion that you were armed and dangerous? Was it actual probable cause to feel like that was contraband in your pocket? And those things don't always line up. What the cop is going to do at the moment and what a judge maybe is going to say 5 months later. And one of the reasons it doesn't always line up is usually you don't get to that point 5 months later. They frisk you, they don't find anything. Okay, fine, go away, whatever. Well, you're not getting charged with a crime, so you don't have a lawyer, you're not moving to suppress evidence. No one ever evaluates whether that frisk was okay or not. So there can be a big gap between the two. And that's part of why training and accountability within the police department is important, because the courts are only going to do it 1 time out of 100.
And just to wrap up with that, and then I know we got a couple of questions. So both situations have to do with the officer's impression of the situation. So just kind of like what Jonathan said, I understand what your position is, but unfortunately with the interaction, how this is, it's from the officer's impression of the situation. Yes, sir.
All right. Just a brief question. Well, 2 questions actually. First one, I'm just trying to understand more about the consent to search, because I remember, well, actually, personal situation. A friend and I got pulled over for like a tail light or something, and I remember the officer asking my friend who was driving if he could search the car. And my friend said, yeah, like, because there wasn't anything in the car. So I'm trying to like think of like, if that was legal, like what, like by him giving consent to search, like, was that okay? Like, should the officer have asked to search? Like, was it probably like, all of that is, I'm trying to remember all that.
Well, we're going to go through warrantless searches, but one of the exceptions to search property or persons or things is if you give consent.
Okay, got it. And that's what I was trying to clarify. Okay.
Right.
And then the other thing, I'm thinking about weapons also, because laws are changing throughout the country and people are being allowed to openly carry. So now are you considered armed and dangerous if you're just carrying your weapon? Like, that's kind of,
Well, again, I think that goes back to the officer's impression of the situation, kind of the totality of the circumstances. Yeah. And whether an officer approaches someone just based off of what they look like versus whether it's on the basis of, does he think a crime is happening? Does he like, so it's still those 2 bases, but I understand that can further potentially further complicate the impression.
Thank you.
Just on that, I would say that, Terry was decided in the 60s, and I think it was decided in an era where it was like, only in certain circumstances are the police going to reasonably believe that someone is armed and dangerous. Mm-hmm. Today, I think many police officers, if they would talk to you, would say, whenever I stop somebody on the street, I'm afraid that they have a gun on them, because everybody's got guns and we got all this open carry. You don't even need a concealed carry permit anymore and all this kind of thing, right? So there's a tension right there that the law still says you have to have kind of specific reasonable suspicion for why I think you have a weapon on you. But because guns are so prevalent, the officer's perspective are, well, it doesn't take much if I'm stopping you for me to say I'm going to frisk you, right? So there, I think there's a tension in the law right there. Yeah. There have been some court decisions, one out of the 6th Circuit governing in Ohio here, that says police get a phone call, say some guy's walking down the street carrying a shotgun. This is freaking everybody out. There is no reasonable suspicion to even stop that person, ask them some questions, because it's open carry, and open carry is lawful in the state of Ohio. So you see somebody walking around carrying a gun, you can call the police if you want, and the police can go over if they want, but they cannot stop them. They can't search them based on they're holding a gun. It's not enough. They have to be doing something else that's suspicious. But that's an area that's very hard for I think, police and courts to figure out what the rules are these days.
Okay, I'm just going to talk a little bit about the high crime area. Very good. Yeah. So a lot of people mentioned about what if you are in certain area and the area is known as high crime area. The Supreme Court actually made the decision about that case in a case called Warrant. So it says that just avoiding eye contact, running away from police is not enough to justify reasonable suspicion. However, if you are in an area known as high crime area, based on the totality of circumstances, if you are running away from the police in a high crime area, that will justify a Terry stop, meaning that the police could have an articulable suspicion that you are engaged in some kind of crimes. Okay, so what is high crime area? When I was in San Francisco, I worked with the police department. I told the chiefs that give me an hour. I can make any area in San Francisco a high crime area. I work with data. I can play with that. I can manipulate the information. And you will have a pretty good reason to say that that is a high crime area. What about Chicago? Is the entire Chicago the high crime area? So that concept is confusing for 2 reasons. What is high crime? If you go to New York, you go to Wall Street, there's a lot of white collar crime. Is that high crime? The second is, what is area? How do you define area? So Supreme Court is giving us a term that is almost impossible to define. What's the conclusion? That means we give police department a lot of discretion in defining what is high crime area. So it's really frustrating.
Yes.
Watching you talk about my hometown
So I guess I just have two like questions, especially if you come from a high crime area. I know a lot of people have the talk with like children and things like that about complying. So the act of really having that power to say no or a stop sometimes seems, especially if you don't know the law, it seems very difficult at times. So that's just a point that I have in mind. And then two, when we talk about open carry, I was under the assumption, and I hope you can clarify that if you have a gun that it's not supposed to have the bullets in it. So I'm not sure if that's correct or accurate information. So, okay. Okay. Thank you.
Don't be very crazy.
Yes. I'm gonna come back to you. Yes.
Yes, I just wanted to make a comment in terms of high crime areas, because one of the things that has happened in Cleveland a lot, having worked in Garden Valley for 13 years, and then you see the data published saying that Garden Valley is always in the top 5 or top 10 high crime areas. And we have had a lot of incidences with police because of that kind of approach, because of that kind of data that's released. And it's published that way, that this is a high crime area. And we have seen an increase in police and community interaction because of that. So I'm really glad to hear you talk about that, because I'm also one who believes strongly that data can be manipulated to fit whatever situation you want it.
More police encounter means more crime.
Right, exactly.
Right. So on this high crime area, I will say that, sometimes it depends even what judge you're in front of or what, it does depend on the particular facts. So I did have a case in federal court a number of years ago that came out of Cedar Estates, not too far from here. Okay, right, central area, Cedar Estates. And there were a couple young black men in a car parked in the middle of the night, 2 a.m. or something, in a high crime area. And a CMHA officer came up, pulled up right behind him. So they were seized immediately because he pulled right behind him and blocked him, had an interaction with him, eventually found an illegal firearm. The district court judge here in Cleveland said that was reasonable suspicion, high crime neighborhood. They were there in the middle of the night, right? And I appealed the case to the Sixth Circuit and I won. So, right, so that was right on the borderline, but the judges in the Sixth Circuit, and I tried this to make this theme in front of them, that like, people live in these communities, and if the high crime neighborhood rule means if you live in this community, the police can stop you whenever they want to, that, I argue to the judges, that should not be the rule. There has to be something else. And the articulable suspicion here was there were some men at night in a high crime neighborhood. They live in that neighborhood. Yeah, they're present in that neighborhood. And frankly, the facts showed that they were there on a booty call. That wasn't working out for them. It wasn't working out. And the Sixth Circuit reversed and said there was not reasonable suspicion there, even though it was a high crime neighborhood, right? So that is a very dangerous factor. It gives the police a lot of discretion, but it's not, hopefully, at least not in every case, just a free-for-all. Once you say high crime neighborhood, at least in theory under the law, there still needs to be something more than that.
Thank you.
Yes.
So I did, yeah, so exactly, like, my concern is, when we label something as high crime, what does that mean? We never ask, what is causing the crime? What are causing the interactions, if it's domestic issues and everything? What is the role of poverty, inequality, economic stressors on creating those situations? And I would also ask, why are there high crime areas, right? Unless we believe that certain people just only have the moral disposition to accomplish certain things in life, right? I always ask my students, why are there white neighborhoods? Why are there black neighborhoods? That's not going to me a natural sense of how human beings relate. But I wanted to, and I want to give one example. Of my boyfriend works in a fire station. There's one black firefighter. It's in a white-ish neighborhood. All he did was go to the gas station after work to get gas, and 5 police cars surround him to ask him what he's doing there. He's the firefighter, right? But he didn't have the uniform on. So I think all these things interact. I did want to go back. I'm a little bit confused. If the Fourth Amendment is protecting against unreasonable search and seizure, why is motivation not a consideration? Was that something that was a historical interpretation that aroused? Because I would think that reasonability is about motivation.
That's a loaded question. The answer.
But there are a lot of ways. I'll try to give a simple version of it, which is when we say motivation is not relevant, we mean that the officer's subjective intent is not particularly relevant. And the court has said, well, it's going to be hard to figure out what the officer's subjective intent is. So we're going to apply an objective reasonableness standard. We still look at that from the perspective of what the officer knew at the time. So, for example, you know, in the case that I had right over at Cedar Estates, the court was like, okay, well, tell me everything the officer knew at the time. He knew that it was a high crime neighborhood. He knew that these gentlemen were sitting in the car and it was 2 a.m. For example, one reason he said he pulled up behind them is that he saw that they didn't have a front license plate. And so he thought maybe the car didn't have a license plate. So he pulled up right behind them. Well, he immediately discovered that there was a valid temporary tag on the back of the car. You don't have to have a front license plate if you have a temporary tag. So all of those things are looked at from what the officers knew at the time. But then the court is going to say, I'm not asking whether you, this police officer, actually thought there was a crime being committed, because maybe you did, but it wasn't reasonable for you to think that there was a crime being committed. Maybe you thought these guys, you genuinely thought they were up to no good. But based on the objective factors, you're there in the middle of the night, you have a valid temporary tag. There's no reason for you to think these guys are engaged. That's not enough, right? So that's what the objective part of it is supposed to mean. You still look at it from the perspective of what did this officer know? Because they don't know everything that's going on, right? But then you look at it objectively, like what was that reasonable based on what they knew at the time?
So I just, as a follow-up, what do you recommend a citizen do, a normal person, if they are ever in an instance that they believe that there should not be, they should not be searched, they should not be detained? What would they do to comply, given the fact that, are we going to wait for that court case? Are we going to wait?
So I guess I would say, right, comply, but don't consent, right?
Right.
There's a very fine line there, because as the example here, my friend said, yeah, you can search the car. That's fine. It's fine to consent to search the car, other than now it doesn't matter whether the police had probable cause to search. It doesn't matter whether they had, because they got consent. So now the rest of it's out the window. If you comply, you say, I'm being polite, I'm being cool, but no, I don't want you to search my car. Then they might search your car anyway, but they're going to have to prove that they had probable cause to search it, or they're going to have to prove some other reason. But if you said, yeah, go ahead and search it, well, now we're done. Now it was lawful for whatever reason.
I was just going to say, I've been in situations like that. I remember once I got stopped, and it was like the officer couldn't get anything on me, so he wanted to search the passenger in the vehicle. So in instances like that, I always refuse consent, and then I always request a supervisor. And that's sort of how I've dealt. Whenever I feel like a situation where the police is going to go left, I ask for their supervisor, because it, as a black man, it is now getting potentially dangerous for me. So that's how I handle those situations. I feel like they're about to do something that, I've explained the law to them, and I've had police officers tell me to prove to them that the law is the law. And then I just ask for the supervisor, and I have to sit there and wait.
I just want to say this, just kind of, I appreciate everyone feeling comfortable enough to share personal experiences. This is so the role that we have with Cleveland State is to inform you of the law. And then at least your role, at least with the commission, in terms of being the law, but then the oversight of the police. And I understand that there are a lot of, I think more so with this conversation, we're kind of learning what gaps there are, what needs to be fulfilled at least, or what needs to be covered with that. So I just hope that this just continues to remain fruitful, at least with the next 2 hours that we have. So I'm going to move forward to search warrants. Search warrant must be supported by probable cause and particularity. This is the law. This is what it says. This is what it requires. Ohio Criminal Rule 41. So the authority to issue a warrant upon the request of a prosecuting attorney or law enforcement officer. Search warrant is authorized by this rule, may be issued by a judge of a court of record to search and seize property located within the court's territorial jurisdiction. So a court can give, so the court can provide allow a search seizure as long as within its jurisdiction. So Cleveland or Court of Common Pleas for Cuyahoga County can give a search warrant for what occurs in Cuyahoga County, in that area, essentially what it's saying. Part B, property which may be seized with a warrant. A search warrant may be issued under this rule to search for and seize any evidence of the commission of a criminal offense or contraband, the fruits of a crime, or things. This is where the particularity part comes into play, just this part. So these are the things that it's kind of saying. So the contraband, the fruits of the crime, other things otherwise criminally possessed, or weapons or other things by means of which a crime has been committed or reasonably appears about to be committed. So I made this kind of in other words, just to make it as clear as possible. Warrants a document issued by a legal official authorizing the police to make an arrest or a search of the premises. Again, what does a search warrant require? Probable cause, oath or affirmation. So meaning that an officer can necessarily give testimony in terms of like, this is what I saw. This is what we have. This is what so things of that nature. So they have to be honest. That's the goal, being honest. And then particularity. So saying a specific area, what they're seizing, what they're looking for. So kind of think of it, because in the law we do acronyms. So I know I have food examples, and the other thing is an acronym. So it's POP, particularity, oath, and probable cause.
Awesome. Okay, so sit tight and let's just hang out for, so we're going to do a brief discussion again about the issue of warrants. You've heard of the idea of no-knock warrants, so where the police enter without knocking ahead of time. So obviously after the killing of Breonna Taylor, a lot of talk about this. The city of Louisville banned no-knock warrants. Prosecutor Mike O'Malley, I saw in a news article soon after that, said that the Cleveland police rarely use no-knock warrants. But to my knowledge, the police do not actually disclose how many of these do we get in a year? Do we get one? Do we get 100? I don't know. We don't know how many no-knock warrants or no-knock entries are conducted each year. So let me just briefly say, right? What do you all think about this? This commission could recommend, or I don't know, right? I think you may have the last word on search and seizure policy. I'm not sure. Police, like Cleveland, we should not do no-knock warrants, or yes, they're justifiable in some extreme situations, right? No-knock warrants, the justification being we have really good reason to believe that people inside this house are extremely dangerous. We know that there's contraband in here, and if we knock ahead of time, they're just going to get rid of the contraband, and they're probably going to shoot through the door, right? If they know the police are out here. So we need to do a no-knock entry in this situation. That we see from the Breonna Taylor case, how that can go extremely sideways, right? And result in a horrible, killing. So let's just throw that one out there. That's the kind of thing that you all, I think, need to think about. So what do you think? No-knock warrants. Sir.
Personally, I don't see a scenario where there should ever be a need for a no-knock warrant. I mean, now, correct me if I'm wrong. I don't know the exact procedure of no-knock warrants. Going by what I see on TV is like a knock warrant, for instance. CPD, boom. Like they just allow CPD and knock the door in. I think that's enough. I mean, just to walk up on the door. That was an unspeakable tragedy for unnecessary reason, in my opinion.
Anyone have anything else to add to that? Yes.
Sorry.
This also reminds me of the case in Chicago, the Young case, where they did do a no-knock warrant, but also I'm trying to understand like the reason for the warrants, because I know like in that case, the warrant was issued by a prosecutor because an informant told the court that they pointed to the house. And the woman wasn't killed, she was instead strip searched when they got to her house, and come to find out she was like a social worker or something. She had nothing to do with the crime. But because this informant just lied, pointed this house out, the officers went to the court and was like, yo, this is the house. My informant said this is the house that you issued this no-knock warrant. This woman was strip searched, and her house was ransacked. And like, I think in Chicago, they also have had discussions about no-knock warrants as well, like banning them. But also, I'm confused even of like just getting to that step of trusting the, I guess, this type of just testimony of like a regular person that this is a crime and they're allowed to get this warrant to just come in your house. Like,
Right, just a question about the warrant itself,
Yeah,
whether it's no
like-
knock or not. And that's definitely one of the huge issues in the Breonna Taylor case is, apart from the no knock, they did not have probable cause to believe that this house had contraband or criminal activity in it. And the police have been, some of them have been indicted for lying in the affidavit that they knew that packages are being delivered to this house. And that is something they just made up, okay? So that's just the warrant process. So what comments from either of you about the integrity of the warrant process, and is there really probable cause?
Police can rely on informant information and anonymous tip, even if they're anonymous. They can. Again, it's the oath and affirmation. So it is they present it to the judge for it to be true, not for it to be somebody just made something up and then we're just going to get asked for a search warrant for it. So I understand what you're saying that wasn't true, but I guess if the officer reasonably believed this person's information, they were under oath and getting this, then it was presented as if it was true. Yes. And then we'll go to you.
So, I believe part of the issue with the Breonna Taylor case and no-knock warrants in general is that you cannot guarantee that the suspect hears that it's the police and doesn't know that if it's like an intruder, right? You just can't guarantee that they hear you, or they know who you are, or they like believe that you're the police, right? And they're not trying to break into your house. And so, I mean, if someone tries to bust in your house and you have a weapon legally in your house, like what else are you gonna do? And so I think it puts so much burden on the suspect, and puts a little burden on the police.
Okay. Kyle,
The question is, should Cleveland ban the use of no-knock warrants? I think the question for me is, based upon what you all said, the amendment, federal law, state constitution, do we have the right to ban no-knock warrants in the city of Cleveland? Or is that protected under GPOs and things of that nature?
I mean, I think it is permitted under the GPOs right now, and the question might be, would those be amended at some point? Would be amended to say, okay, now we're actually not going to permit that, right? I don't know exactly how Louisville did it, if they did it with a city ordinance or if they did it through a GPO. I'm not really sure, right? It wasn't the state. There was talk that the state of Ohio should ban these, but of course that didn't go anywhere, right? So I can't answer your question directly. I don't know. You all are going to have to, as you move forward, get a sense of what are our powers as a commission? Where do we fit into this system? And where are the points at which we can say, no, actually on this one, we get to have the final say. Maybe you don't have the final say, but maybe you have a say, a word that you add to the process. That's just something y'all are going to have to figure out as you move forward.
So if you look at 115, you guys have a couple of different options with something like this, right? You can participate in the legislative process and work with counsel and say, here's the reason, right? Or you can take it from the police department and talk about it as an issue there with maybe having the final say in their policy. Now, I'll give you a good example, right? We can ban, and we've heard that Cleveland City Council has banned minor misdemeanor marijuana complaints, right? Where do we come into a problem there? All right. Police under Ohio law still have the authority to write you for a marijuana citation because Ohio law says that they're allowed to do that. So the difference is the money and where it goes to court is through the state court, right? So whoever would handle that state complaint is the one that will handle that case. So there are ways that we can approach something like this, right? But we have to think about it holistically. We have to look at what exists already. We have to see who our partners are, who's willing to have that conversation, and then move forward.
Question, yeah?
So I just want to give a comment on the last slide.
Yes.
I don't even think that the question should be asked until, to me, it's when Michael O'Malley says very rarely use knock warrants, that they don't disclose data. How can we even make an evaluation of the no knock warrant without the data? And we have we have a episodic data with one person, and what I'm struggling with is that it takes someone like Breonna Taylor dying, which is irreversible, for the law to catch up, rather than anticipating. Let's think of the scenarios. This could lead to a reasonable, concern from a person that it could lead to tragedy. The other issue I have with it is that if it's in a neighborhood that's already labeled high crime, as someone has mentioned, the suspect is not going to respond in the same way. How do they know that, so it's like kind of like we label something and we just double down and push it towards a point that the eventuality is always determined, unfortunately, against the citizen. So do you have any, my last point is, if it's something that's like, oh my gosh, they're part of a drug cartel or something like that, is the local police the right people to handle that? Would not the level of training that maybe the federal police have, I'm not saying that they necessarily, would not make mistakes, but why is it the jurisdiction, I'm just saying, if the motivation is like, oh my gosh, there's this big crime happening, would the local police even have the jurisdiction or the ability to handle something like that, such that it would necessitate a no-knock warrant at the local level?
Sure. So let me just try to say a few brief things before we keep going. So I think that, first of all, I do think, as Lee Fisher said, right, it is the role of this group in part, also the responsibility of other people like City Council and the Cleveland Division of Police, to try to set the appropriate guardrails ahead of time before the tragedies happen, right? And I think looking at the issue of no-knock warrants is important. And I also really agree with this, which is looking at the issue of how regular warrants are executed. Because as you said, if you look at the case law from England 400 years ago, they say the reason you knock before you go in is to give people enough time to understand that it's the police and to come to the door and give them a chance to open the door. And if the regular procedure is Cleveland Police and now we're in the door, they're not doing that. And they're creating the same danger as a no-knock situation, right? So maybe we need to look at how are regular warrants being executed? Are people really being given enough time to understand what's going on, come to the door, not create a violent situation? I think that's a legitimate, and serious issue. And then I forget. I'm sorry. Your very last issue then was about.
I'm assuming no-knock warrant. The reasoning is that we don't want them to hide the evidence, or.
So I guess I would say that the idea that if it's a more serious case, the feds are probably going to be involved is not correct. Is not necessarily correct. Federal authorities have certain jurisdiction over certain things, but it doesn't. There's a common perception that if it's really serious, it must be federal, and that's not really accurate. So, the most serious crimes in Ohio, in every state, are capital murder cases. Those are usually not federal offenses; they're state offenses, and they're under the feds would have no jurisdiction over them. They're under the jurisdiction of the police. So, it depends. There are some cases where the feds are involved, but it's not automatically, if it's more serious, the feds must be involved.
If I go to ask, it's a real important question to ask, because law enforcement doesn't always operate in silos. You will find there are a number of task forces on a lot of assortment of issues here in Northeastern Ohio that involves multiple roles for law enforcement. One of the things you need to look into is, what do they look like? What authority do they operate under, and how these decisions get made within a multi-jurisdictional task force?
Yeah, question there.
I'm just gonna say, there's a lot of collaboration between various federal, state, local law enforcement.
Definitely.
Also, when you're doing a warrant, a lot of times you have eyes on the place where you're gonna go in to make sure you're gonna hit the right place. One of the best ways to do it is you wait for your primary guy, the most dangerous guy, to go out to whatever he's doing.
Right.
If you got
Get
some
him
undercover
separately.
cars, you get him separately, you go back and hit the place.
Agreed. Absolutely.
That's one way to make it a little more safer for everybody, because officers get killed on warrants quite a bit. We had, Schroeder was killed off of 98.
Correct. And I agree with you that this is an area where hopefully you could find positive collaboration, because it is, of course, in the interest of the police. They want their warrant executions to be done safely. They know there's danger involved, and they don't have an interest in creating a dangerous situation. It happens anyway sometimes where they do create a dangerous situation. So I think that can be based, I don't know, on misperceptions, but hopefully this can be an area where you can find common ground where the police don't want to put themselves at risk unnecessarily either. I agree with that. Okay. Following on Khalid's model of let's use acronyms, right? When we're teaching our students, there are exceptions to the warrant requirement. So Khalida talked a little bit about getting a warrant, an arrest warrant or a search warrant, but there are many circumstances where the police can conduct a search or a seizure without needing to get a warrant. And this is a basic list of it. There's a lot of law here, and I'm going to try to kind of move through some of it quickly because this is like half of our class right here, right? This is like 7 weeks worth of material. But spaces, right? Search incident to arrest, plain view, automobiles, consent, exigent circumstances, and special needs. We've talked about this a little bit already. So like I said, I'm going to move a little bit quickly. You'll have these slides. So if you want to read these more slowly, I think that would be a great, because these are very detailed rules. So search incident to arrest, as Stephen said, the basic rule is when the police arrest somebody, they then get a pretty broad search authority. They can search the person, and I don't mean pat down, I mean go into their pockets, open up their wallet, look through their bag, the possessions they have with them. It's a very broad search authority, and the one exception is this item right here. They cannot search your cell phone, incident to arrest. They have probable cause that you have evidence on that cell phone, they can seize it and get a search warrant to open it. So it's an important exception there. If they arrest you in the building, they can also, under certain circumstances, do a protective sweep. Check the areas adjacent, see if there are other people present, okay? So you're exactly right. For a protective sweep, you're looking for people, and so you wouldn't start opening drawers because you don't have a person in the drawer. That's exactly right, okay? But the person and the stuff they have with them, that's a very broad search authority. So that's search incident to arrest, very common way that searches are done, right? Somebody gets arrested and they search them incident to that arrest. Plain view is the idea that the police can use their non-touch senses, their sight, their hearing, their smell, if they're lawfully present, either on the street or in somebody's house because they were invited in or they had a reason to be there. They can use their senses. Those are not a separate search or a seizure, right? If they smell something, they're permitted to do that, okay? One mistake that the police sometimes make is that they know that they're allowed to see or smell or whatever, and they think that that also then gives them the authority, okay, I saw something, and so I can then enter that home. And plain view allows you to see it, but it does not give you the authority to enter. So, for example, you see, contraband through a window in somebody's house when you're on the sidewalk. You can see that, but now you need a lawful reason to enter that home. You would need their consent, or you would need a search warrant, or you might have exigent circumstances. We'll talk about that later. But the mere fact that you saw it doesn't automatically allow you to get in. Automobiles. So we can have, a whole chapter on automobiles. There are a lot of rules. But one basic important one is that essentially search warrants are not needed for automobiles. If you have probable cause, which is the thing that you need to get a search warrant, and the probable cause relates to an automobile, you can skip the search warrant part. That's the automobile exception. To enter your house, they have probable cause, they can't enter your house. They need to take that probable cause, go to a magistrate, get a search warrant, right? To open your bag, they need a search warrant, unless you agree to let them into it, right? But for an automobile, If they have probable cause, they can simply search the automobile. Now, again, later, if you challenge it in court, there's going to be a judge to decide, did they actually have probable cause? Was that correct or not? But the point is, they do not need to get a warrant for automobiles.
Does it matter if you're in the automobile? or
It
if
does
it's
not.
with you?
It doesn't matter. You know, the automobile's sitting on the street out here. There's nobody around. There's no chance it's going to drive off, right? The cops, right? It doesn't matter. It's a very blanket rule. If it's an automobile and you have probable cause, you can search that. Doesn't matter. You don't need a warrant. Okay, let's do another example here. All right, automobiles, probable cause. You're driving your friend home from the store. You're driving about 40 in a 35 mile per hour zone, which usually you're not going to get pulled over for, right? It's not raining. It's not dark, whatever. Ordinary, there aren't school kids around. But this time the police pull you over. Officer orders you out of the car and starts searching your car. They say, we're searching your car because it matches the description of a car recently used in a robbery. The description of the car from the robbery is a late model black Ford Focus. You're driving a black Ford Focus and it's 10 years old. So 2 questions. Did the officer unlawfully stop the car? Was that initial stop, was that lawful? And secondly, did they have probable cause to search the car? If they have probable cause, they don't need a warrant. They can search the car. Late model means old. Right? You know that? You've had a few late models? What do you all think on this one? Legal stop? Why do you think so?
Because we were over the speed limit.
Very good. And so the court has said that, the Supreme Court has said, even though you usually might not pull over somebody going 40 in a 35, we don't care. As long as there is objectively, you're violating the law, we can, it doesn't, you know, it makes me suspect in this scenario, they didn't pull you over because they were motivated by he's going 40. They pulled you over because they're like, this might be that kidnapping car. Let's pull him over for that reason. But they had a objective reason to do it, so it doesn't matter why they were doing it, because they had another reason to do it, okay? What about this? Did the police have probable cause to search the car? You think no, why not?
I think no.
They had some particular facts.
You would need more. If you had the suspect description matching the driver or something like that, clothing description.
Why is that not enough? It matches pretty exactly.
There's a lot of cars like that. There's a lot of, it could
Quite
be
a few.
Super generic description, right?
Right.
So it matches very carefully, but it matches a very general description. As you said, can we get something else? A description of the suspect. If you match that plus the car, now you're probably there. Or if, of course, if you have a license plate number of the car, that helps, right? Or, you know, it's missing both of the back hubcaps and it's got
details, anything.
yeah, details, right? You get details where it becomes more reasonable to say, I really have a good reason to think this is the exact car. Then yes, you have probable cause. In this fact, agreed. Too generic.
Listen, I wanted to ask this before. It's on the hunch phase, right?
Hunch,
and this
yeah.
is not consensual.
Right,
They pull you over on a hunch,
right.
and you say, no. Does that raise it to reasonable suspicion?
When pulling over is non-consensual.
Correct. But usually when they pull you over, it's because of this, right?
Right.
I
I'm
pulled you
talking
over because
about-
you didn't use your turn signal or you went slightly across the line, right? So we have a reason to pull you over.
Mhm.
But now we say, can I search your car? And you say, no. And now you're worried the police are going to say, well, that's suspicious that he wouldn't let me search his car.
That's what
And that gives me more reason to search the car. Objectively speaking, the answer is no. That does not contribute to the reasonable suspicion or probable cause. The tension here for people on the street, I think, is they know if they say no to the police, subjectively, the police are probably going to be like, oh, I'm a little more interested in this car now. But objectively, under the law, the court will say that is not relevant that you said no. Very fine line for people to walk there, right? But in theory, at least, saying no is not enough. It doesn't add to the suspicion level.
hunch isn't enough to search.
That's correct. That's right. A hunch alone is not enough to search.
That was my question. Can a hunch be raised to reasonable?
Based on
where
saying
they
no.
can't-
And the answer
yeah.
is no, right? You have to point to something else. What often happens is this one right here, right? Police ask somebody, can I search your car? And the person says yes, okay? And people feel pressure to do that, right? You feel like I should comply with an authority figure. They asked me to do something, I should do it. The court's view is, no, you don't have to do that, right? So therefore, if you say yes, that's voluntary consent and that's lawful right there, right? So the police can search anywhere that that person consented for them to search, and that's based on what a reasonable person would understand from the communication. So for example, if the police said, "Can I search your car?" and they said yes, that would include, you can search the entire car, you can include the trunk. But if they start like slicing open the seats to look inside, a court is going to say that a reasonable person saying, "Yes, you can search my car," would not have assumed that that included, "You can cut open my seats," right? So they're going to say that's not within the scope of that consent. One area in which Cleveland Division of Police policy is more protective than the Fourth Amendment, like we talked about earlier, that being possible, is this area of consent. Under the Fourth Amendment, when the police are asking, "Hey, can I search your car?" they do not have to tell you, "And by the way, you have a right to say no." They don't have to tell you that under the Fourth Amendment. Search and seizure policy under this GPO, where an officer seeks consent for a search, the officer shall inform the person in an age-appropriate manner of his or her right to refuse or revoke consent at any time, and their consent to search shall be documented using their body-worn camera. And therefore, we have an objective record of what the officer asked, what the person said, and whether they informed them of their right to consent. So here we have a policy that is giving more protection, right, on this issue of consent than the Fourth Amendment gives, which is fine. Okay? Yeah.
One thing we've talked about a little bit in the rules committee is the difference between shall and must.
Okay.
Are they the same? Like, is it must?
I think shall and must are the same. Yes. Shall means you must do that. Yes. Yes. So when it says shall inform, that's not a suggestion. That's a requirement. Yeah. Okay, here's an example. You're walking down the street with a friend after leaving a store. A police officer says, "Excuse me, can I talk to you for a minute?" You both stop walking. You don't say anything right away. The officer then says, "Would it be okay if I quickly look through your bags?" You don't say anything. Your friend says, "Sure, we have nothing to hide." The officer searches your bag and your friend's bag. Did the officer unlawfully seize you and your friend in the first place? Was the search of your friend's bag legal, and was the search of your bag legal? What do you all think about this one? What about the initial encounter? You think the seize was legal? You don't think it was? Tell me why not? The initial stop. Why?
That was no reason.
Well, they didn't
Just
respond.
for
either.
walking down the street. Why
They didn't give consent. They didn't respond.
No,
Not
that's
responding is
understandable.
not consent, right?
Did the officer order them to stop or ask them if they'd be willing to stop?
Asked and they stopped.
They asked. They didn't say anything, but what did they do?
They stopped.
They stopped. If the officer had said, "Stop for a minute," and they stop, that's an order. They've been seized. This is not a seizure. If they had said, "Actually, we're trying to get to our meeting, we're late," and the officer said, "Just stay here for one more minute, I just need to ask you one question." Now they've been seized. You got to give, what was the reason for it?
There's no reason.
I agree, but for better or for worse, under the Fourth Amendment, they don't need any reason to say, "Excuse me, could you stop for a minute?" Doesn't matter why. If you stop when they asked you if you would, the court's going to say, "Well, that was just consensual," right? Okay, because they stopped. Because if they had kept walking, it's fine, and it shouldn't give rise to any reasonable suspicion. Because it's consensual. You should be able to say no and just keep walking. Okay. What about this second part, the searches of the bags? Yeah.
I think the friend's bag search was legal because they consented, but the search of your bag is illegal unless the friend was holding it, I was guessing. So like if the friend
That's
is
very
holding
close,
your
yeah.
bag,
Unless the friend
like,
is, well, it's just your bag. Whose possession is it?
Yeah.
right, but how
Good.
could the officer know? I mean, I guess unless you
He
said
should ask.
something, but yeah, they couldn't search your bag because you didn't consent.
So I think that the basic answer there is correct, right? It was the friend who said yes. You didn't say anything. You stopping is a way of consenting to the stop, but you not saying anything is not a consent to search your bag, right? You're actually gonna have to say something to say, "Yeah, you can search my bag." There is no reason for the officer to think that your friend has authority over your bag. You are correct that if your friend is the one holding both bags and they say, "Can we search your bags?" and the friend says, "Yeah, here you go," the officer then is going to reasonably believe that both bags belong to that person and they consented, so it's a lawful search. But one bag here, one bag there, they can search the person who consented, but not the person who didn't consent. Good.
What if the second person was my teenage son, a minor?
Uh-huh.
Would that grant Can I speak on behalf of the minor? And if I say, yeah, you can search my bag, but I have a teenage son who's a minor.
Yeah, so essentially the test is whether you have kind of access or control over that bag. And if the answer is yes, then you can consent to it, right? But it just depends on the particular facts. Like, do you have the mere fact that it's your, teenage son? That's also like a 13-year-old is probably different than an 18-year-old. The 18-year-old is a teenager, but they're not a minor. Whereas a 13-year-old, probably you do have that authority. Okay, good. Yeah.
Okay, may I give a little bit input here?
Sure.
First part of the scenario, here's already a very problematic situation for regular citizens. According to the law, you just explained. If they did not order me to stop, I actually can just keep going.
Correct.
But ordinary citizen, we all know, if we keep going, even this is still lawful, legal, guess what kind of consequence I probably will be encountered?
Oh, yeah.
I wouldn't say 100%, let's just say 99%.
Yes, I understand. I agree with that, right? That ordinary people do not feel free to say, if an officer says, excuse me, can I talk to you for a minute? To just say, I'm going to keep walking down my way. I think that's correct. Ordinary people don't feel free to do that. And if they did it, I too would be concerned about what the response from the police might be. And so again, it's an area where what the Fourth Amendment says under the law and what the court thinks about and how people actually feel and behave on the street is, I think, very different. And that's a problematic area.
And
this area of consent is a very problematic area.
And I would like to emphasize the response from an ordinary citizen. We are afraid of not stop and having different consequences. That's because the historical experience we have encountered. Sometimes it's not only the people of color. Even white people get trouble in that too. Now it goes to the second part. That's even worse. People do not understand the differences. Even lots of time the police do not understand the differences. If you don't say yes, and they will still get your bag to search. I think there's a term called probable cause or something like that. We learned it from TV. Sorry about that. TV and movies. But that doesn't happen in reality. So the law says something, but the street, whatever on the street is completely different.
Understood. Okay. Well, let me keep rolling here and get through a few more important issues. Again, exceptions to the warrant requirement. Exigent circumstances. This is a reason the police use very commonly when they enter a building without consent or a warrant. The police may search, including entering a building without a warrant, if they're in hot pursuit of a fleeing felon, so they're chasing someone who they have probable cause to believe committed a felony. They can follow that person into a building. Number two, they reasonably believe that they're facing the imminent destruction of evidence. That is to say, if we don't enter, they're going to destroy this evidence quickly, and we won't have time to go get a warrant and come back. The evidence will be gone by the time we get back here. And third, if they reasonably believe their entry is necessary to prevent the imminent harm to themselves or to other people. So they see somebody being assaulted inside a home, the police can just enter the home. They don't have to go get a warrant because the person who's being assaulted, the police need to go in immediately to try to stop that from happening. This one right here, this second reason, is very commonly invoked in drug cases where the police have probable cause that there are drugs inside a home. And final piece, the people inside know that the police are outside. Once you have those two things together, then it doesn't take much for the police to reasonably believe, I think these people are going to try to get rid of the drugs. Drugs are also, in most circumstances, the kind of thing that you can destroy pretty quickly. You can flush it down the toilet, you can do whatever with it, right? And so, right, they wouldn't be able to, if they're they have probable cause to believe that there are a bunch of firearms in the house, you're not going to be able to destroy or get rid of firearms immediately. But drugs are different, right? So this is invoked very, very commonly as a reason for the police to be able to enter a home. Question or comment about that?
One quick question. So with that, that's why I asked before, why would a no-knock warrant even be necessary?
You're right, because they go and they can probably just enter with this anyway. in many drug cases, I think that's correct. It depends on the circumstance. I mean, it depends what the police are trying to achieve, you know, in the circumstances and what they understand about what's going on. Yes.
I guess with drugs though, isn't it kind of dicey because some drugs are pills,
Right?
and so how does those circumstances play out? Because you don't necessarily know if those pills are prescribed. You don't know.
Sure. So the police have to have probable cause that you have contraband. So when I say drugs, I mean, you're right. I have drugs in my house. They're not contraband, right? They're lawful Tylenol and stuff, right?
Well, I think sometimes with our experience with federal law, how it may be coupled is the amount of pills. So possession with the intent to distribute comes from a certain amount, not just like 5 or 6 that are in the bottle. Right.
So I mean, like, Schedule 2, like a lot of ADHD drugs, for example, are Schedule 2 drugs. And sometimes a person might have a large quantity of them just because of, like, there's a shortage of Adderall right now. Like, so you might have a larger quantity because maybe your doctor wrote a certain prescription. And they're not maybe in their original pill bottle or anything, but you actually are prescribed those drugs. But Adderall is like a Schedule 2 drug. So I'm like, how does that play out?
Well, I think, like, as Jonathan had said before, it depends on the circumstance.
Okay.
So, like,
what do the police know?
Yeah, what do the police know with it? Like, what's their overall impression of the situation? So if someone has a prescription and they get it in bulk, I think that's different than someone who has, I don't know, like a bunch of oxycodone, and then they're seeing, there are a number of different factors that I think can make that distinction. Can we say every single factor? No, because again, the lawyer answer is going to be, it depends.
Okay, so to wrap up on these exceptions, right? There's the exigent circumstances and then the special needs searches. And so this, as I said earlier, the search when you have to go into your school is a great example of that, right? From the justification from the police are going to be, that is not a criminal investigative tool. We are not searching people when they come into the school because we suspect they all have drugs or guns or something like that on them. It is rather they're pursuing an administrative goal, not a criminal law investigation, criminal enforcement action. And when they are pursuing an administrative goal, then they kind of have a different test. They aren't always required to have individual reasonable suspicion, individual probable cause, what we've been talking about so far. They can enact a program as long as the program is reasonable in general. And so that, the entry to the school is an excellent illustration of that. Is it reasonable under the circumstances for this school building to require students to walk through a metal detector and to have their bags looked through, maybe, let's say, when they come into school every morning? Would it be reasonable for them to have to go a physical pat down, right? You said maybe that was happening too. I think a court would say that's much more intrusive than having a cop look in your bag, right? When you go into the Cavs, watch a Cavs game, you got to walk through a metal detector and they're going to look in your bag. But nobody's physically touching your body unless an alarm goes off or something, right? It's much more intrusive, so they decide not to do that. There aren't really bright lines here, but when they're doing these administrative things, the courts are going to evaluate, does this seem reasonable? Do you have a legitimate, valid goal? And are you behaving reasonably in doing this?
If law enforcement is doing a welfare check, and I'm thinking especially like mental health welfare check, if someone says, I think this person is in danger of committing suicide or suicidal.
Right.
And then once they go in to do the welfare check, and then if they find, drugs, contraband, whatever, at that point, is the warrantless search just going in for the explicit purpose of searching for the person to make sure they're safe? Or does it become they have the authority to then do any sort of search once they're in the premises?
Yeah, great question. So when I said the plain view rule, right, it means if the police are lawfully present, they can see, they can smell, they can hear. And if they are doing a lawful welfare check on somebody, it's a reasonable goal, and they're doing that, and then they see something while they're there, now that is in plain view, and they're going to be able to like seize that. Now, doing a welfare check on someone, you're in the family room, you're talking to the person who you're concerned about, and you're saying, okay, let me just do a quick search of the house. Well, why are we doing a search of the house? That doesn't have anything to do with anything, I don't think, right? So no, you can't just search the house and see if you can find any drugs or weapons. But you see, a handgun, sitting there on the table next to a pile of cocaine. The police don't have to ignore that. They don't have to close their eyes to it, right? They're going to be able to seize those items, and that's going to give them probable cause to arrest the person, to conduct a search incident to arrest, and so forth. So when they are lawfully present for one purpose, they have to stay within the scope of that purpose. But if they then observe something else that gives them another reason, now they can act pursuant to that additional reason that they have. Yes.
So you mentioned before that you were going to talk about the First Amendment and other,
Yes.
I'm assuming all the Bill of Rights. Could you, there was an interesting case happening right now that applies to like a school setting, and the interpretation is Stanford University. Some parts of the Federalist Society invited a conservative judge.
Right.
And then, there were protests, and
Right.
then Stanford actually apologized. So it said that Stanford had the right to, I guess, apply the First Amendment as it saw fit within its setting. I mean, I don't know if that's the right interpretation, but I can see that the First Amendment, and Second, interacting with the Fourth Amendment in these kind of special circumstances. Could you tell us what schools are one, but where are the spaces that these special needs searches would apply, like the institutions?
So one overall thing that I don't think we've mentioned yet, but which is important, is the Fourth Amendment is a limitation on government action, on state action. So when we're working at Cleveland State University, we are bound by the Fourth Amendment because we are state actors at Cleveland State University, right? At Case Western University, the professors are not state actors. It's a private institution. They are not limited by the Fourth Amendment. Stanford is not limited by the First Amendment. It's a private institution, right? Cleveland State University has First Amendment rules about who we can tell not to speak, who we can, right? We're a public institution, a state institution. But Stanford is not bound by the First Amendment. There's a California state law that says that private universities in California essentially have to do the same thing as if they were governed by the First Amendment. So they are, it does not apply to Stanford, but in a sense, California state law makes the same rules apply to them. It means that they have to kind of follow the same rules as if they were a public university, essentially. So, yeah.
So with the law in this case, this was a public school?
Yeah.
So a public school is those are state actors, right? And so yes, when you're entering a public school, the Fourth Amendment applies. And if, one answer is, did anyone file a lawsuit challenging that policy? Probably not.
No.
And if so, no, people might not. Yeah, okay, years later things happen, I believe that, right? If nobody filed a lawsuit, then no judge decided whether they were carrying out that search and seizure policy lawfully or not. If somebody had, then we would have taken evidence and figured out what exactly are they doing? Are they really physically searching people? That I think would have been a problem for the school to defend that versus just, so it would have depended. But unless you have that lawsuit, they're just doing what they do. Hard to know. Okay. Okay. Let me go on to a big issue, which is very complicated, but new technologies, new surveillance, right? And I'll give a brief introduction to this, and then we can talk about a few examples as a group. So in general, as I was talking about with plain view, the police are entitled to, if they're out on the street, they can see what's around them. They can follow somebody briefly on the sidewalk, right? They don't need a warrant to walk behind somebody. You can walk behind somebody, right? You can look out the window right now and just see what you can see. The problem becomes that there are, of course, advanced technologies that, in a way, are doing the exact same thing. You've got a camera on a street corner. Well, that's the same thing as a cop standing there on the street corner. The difference is, of course, being that the cop's going to get tired and go home and go to sleep eventually. And it would be extremely expensive to always have an officer on every street corner of the city. But it's cheap if you want to put cameras on every street corner of the city. And so it's the same activity, but it just becomes happening at a way, way, way higher level. And so you end up having a much bigger impact on people's privacy, right? And so what does the Fourth Amendment have to say about that? And essentially in this case called Carpenter that Stephen talked about earlier, the Supreme Court said, well, kind of detailed long-term surveillance of a person's movements in public do implicate the Fourth Amendment and require a search warrant to do that, because, that kind of long-term surveillance of where everyone's going could really reveal a lot of very detailed private information about someone, even though in a way you're just doing the same thing as, well, a cop can trail you for a couple blocks on a street, right? On a street, they don't need a warrant to do that. They're just following you a little bit. But if they use a device to do that 24/7 for 6 months, they're going to learn a lot of information about you. So the puzzle is, at what point does what looks like just ordinary lawful police work become something that is more detailed and requires, say, a search warrant? And factors that implicate that are like, is this information kind of collected automatically? Is it stored for years? How detailed is it? Are they generated very cheaply and easily? Does it become a situation where we really can track people or reveal a lot of private information about them? So, for example, the city of Cleveland, as far as I've heard recently, has about 1,500 video cameras at various public locations around the city. Let's say, to my knowledge, they're not doing this, right? They've said they're not doing it. But the CDP just started using software, facial recognition technology, that'll connect with those public cameras. That could be, as you can guess, a pretty valuable tool in certain respects, right? You could evaluate, here's our suspect. Let's see if he's been at anywhere around the city in the last 6 months, right? If you have video, you can maybe just do the comparison and, here's a couple of hits. You might be able to track a suspect, right? We're interested in this guy. Now we'll just, every time you show up at one of our cameras around the city, we'll know where you are. We can kind of follow you around that way. So would that violate the Fourth Amendment if they just started doing that? Or is that, no, they're just using their public cameras. It's like the police being out on the street. They can keep an eye out for you if they want to keep an eye out for you. If they happen to see you, good luck for them, right? They can arrest you, whatever. Would that be a Fourth Amendment problem or not?
It's 24/7.
Yeah.
Right.
Yes, yeah, absolutely.
Right.
Yeah.
Because he's not committing a crime you're just like following. You have information.
Well, the cameras are already there right now, today, right?
Mm-hmm. Oh.
So what's the difference with adding the facial recognition onto it?
Well, can I go back and say that there's a problem with facial recognition technology? We don't know if that technology is accurate. I believe that Amazon has similar technology. They're not just, selling things. And it literally didn't recognize members of Congress as criminals. It was so there's an accuracy. We need to first assess whether that technology is valid.
Sure, absolutely.
But I also think that you're basically following someone continuously, right? But they're not necessarily where's the probable cause? You're just following them until they do something wrong.
Right. Yeah. Oh, I'm sorry. I was going behind you first.
Oh, so I think on the first bullet point, it says that you have a right to feel secure. So if you're always feeling watched, I feel like you're going to be put on ease and always feel guarded. So I would say that. And then also, I think that they can be around. But if I say Greg is a suspect, then you should have probable cause, and you shouldn't just be watching Greg, because you was in the corner of my eye. You shouldn't just be monitoring Greg 24/7. But if there may be an instance, then that may. But I'm gonna take the lawyer answer. That it depends on case by case basis.
Right. Yeah.
Yeah, I'm in very similar agreement. I think that you can't just start tracking everybody. There would have to be probable cause for someone to say, oh, we believe that this person is at this location at this time, and then we could use facial recognition technology to confirm that. But to the point that Commissioner Wong talked about, the data on the facial recognition technology that the accuracy level is much lower for people of color than it is for white people. And so I think that then becomes a constitutional issue if we know that the accuracy rate is different, it has disparities.
Certainly. The interesting question is, would you prefer that the system be more accurate for your group or less accurate? There's a double-edged sword there, right? It's not necessarily better if it's more accurate for your group, but you could go either way on that one. I will say that that study is definitely out there from MIT. It is a couple of years old at this point, and this technology, if y'all been following, AI and stuff, every 3 months it's 10 times more accurate. So I think at this point, the best facial recognition systems are extremely accurate. I'm not saying that's a good thing. I'm just saying I think that's the state of the world at this point. If they want to use it, I mean, maybe not. So, it depends. So
the question becomes do you need a warrant for this?
Do you need a warrant? That's exactly right. So the question is not, are police ever permitted to do something like this? But it's like, are they going to need to show probable cause in a warrant? Here's why we need to figure out where this person is, versus we just get to do it whenever we want to do it. That's exactly right. And so, I will say that I think that the Cleveland police are, sensitive to this issue. And the other thing that this example illustrates is you can have a technology out there, a bunch of cameras on the street corners, and whether you're violating the Fourth Amendment or not does not just depend on, are the cameras out there or not? It depends very heavily on how are you using those. If you use those in a kind of limited way, we had a robbery at this particular street corner, let's see what the camera shows, who might have been there. That's going to be probably viewed as, that's fine, you don't need a warrant to get that. But if we're tracking somebody around the city hall for a month, we probably do need a warrant to do that, right? So how we use the technology may be lawful or unlawful, not just is the technology there, okay?
So I have a question. I think, if I'm not mistaken, council entered into like an agreement with the manufacturers of stuff like ring light and those like video doorbells,
right,
that they can subpoena that. And so
right.
I was wondering,
Sure.
like, what doesn't that infringe on my personal right? Like, I bought the ring light for my house,
right?
But now the government in the city I live in has a contract that they can subpoena my video stuff without telling me, because it's a contract that they entered into. Doesn't that go against like my constitutional rights?
Yeah, that's a great question. Yeah.
I'm a private investigator and a lot of I subpoena those all the time.
There you go.
I subpoena them.
It's very helpful, right?
I got 3 cases right now. I went through Arlo, went through the corporate counsel. Hey, we got a criminal case. He said, send me the subpoena and I'll get the information.
So
a lot of times what they'll do too, a lot of times they don't store it. You can take it to the owner and let the owner
and get it from the owner. It's easier to get it from the company because
Right.
it's just more but
exactly.
if it's
But on some of them that I'm nice about, I let the owner know, hey, listen, I'm Ms. Bickerstaff, I'm a private investigator. I did subpoena your footage. They have this amount, you have the other amount, and I need you to surrender it over.
Even if I'm not a suspect?
That if your camera has something out there that happened that I need for our client that's accused of a murder, or robbery, or rape, or whatever, and we need that video footage.
So, that's exactly right. And let me say, one debate would be, should a subpoena be enough to get that, or should you require a search warrant to get that, right? A court order, right? Or a search warrant to get that. But the basic idea that, if you get a search warrant, the warrant for information, for items, for evidence, does not have to be targeted at the person who you believe committed the crime.
Right.
If I believe that there's evidence of a crime in your house, I'm not suspecting you at all. I can get a search warrant to search your house to get that evidence. It's not about you, it's about the information, like she said.
And that's
So if you have that record on your device that recorded a crime being committed, you can decide whether you want to have that device in the first place. But if you have that information now in your possession and the police can get the appropriate legal process to get it, it's not about you being a suspect or anything. It's about the information they can be entitled to if they go through the right legal process.
But then in your subpoena, in my subpoena, I put it's only for
This purpose.
this incident that
Yeah.
happened on this date and time. Nothing else.
You're not looking at other things.
No.
Sure. Yeah.
I'm focused on that one
Yeah.
incident.
Oh, I just had to clarify.
That's fine.
I guess that's very interesting because like if a crime is committed like next door to me and I don't have a camera,
Right.
police come, they knock on my door,
Right.
and I open.
You can
the
decide
door,
whether you're going to talk to
and
them or not.
I don't have to talk to them, right? Like I might
Correct.
and it's like no snitching. Like you don't. I probably did see the crime. You don't know. I
You get to
can
decide.
Yes, but if I have the camera, it's like I don't get to decide. At
That's
all.
correct.
It's not my personal. I don't have any right to privacy or.
You do have a right to privacy, but it's overcome by the legal process they went through to say, we have, if it was a warrant, probable cause to believe, or a subpoena, you can throw the right standard, that this information is relevant to an ongoing criminal investigation, and therefore we can go through that legal process. Like she said, it's still targeted at one thing. It doesn't mean police can say, give me the last 6 months of your Ring camera. I want to see what's going on in this neighborhood. They can't do that. But for a particular crime, a particular time and date, they are entitled to get that.
But let me just say this, the lawyer of those, like Ring.com
Sure.
or Harlow, the lawyer will tell you, we want a court order. Or we
Yeah,
want a search
they
warrant.
want more.
They'll let me know.
If they want more.
You know what, this Harlow may say, we want a court order.
Yeah.
Ring.com might say, just send me the subpoena.
Got
So
it.
it depends on the company.
Sure.
Or the way they have their policy set up.
And I think
what
that's
they want.
in part because the law here is a little uncertain.
And what
Because-
they're is not in the state of Ohio.
Right, if at some point the US Supreme Court said that information is so private that it's protected by the Fourth Amendment, then all those companies would require a search warrant to get it. But right now, the law is not clear, so some of them require a search warrant, some require a court order,
Right.
some just require a subpoena. It's all over the place, so, yeah.
Any recording too?
What's that?
Any recording.
Any recording, right.
Any evidence, right?
Right.
So any
Subpoena,
recording,
you're,
right? So.
from your cell phone, you were at that location, I know you were recording,
100%.
I'm entitled to that
That's
from
like
your
the
cell
easy way
phone.
to think about it, right?
Yeah, yeah.
It's, the Ring camera is like one specific thing, but if anything's on your phone.
Sure.
If you have a voice recorder,
Yep.
right, and you took, and it was on when something happened.
Yep.
They're entitled to all that if they look at it.
Correct.
So to answer your question, Alana, I think that what's interesting is historically, right, the fourth, everything they wrote was to prevent what they experienced in the American Revolution, to prevent another tyranny. However, how the Supreme Court has not ruled on that, this wasn't just with Ring, this was the FBI tried with Apple to get a backdoor entrance into the iPhone. So the larger issue here is, if you that are parts of our government are much closer to the corporations than we think, that there is, a merging of those two entities, and how much security you're willing to have is probably going to be an issue of privacy. Like that TikTok thing was, right now, the US government is trying to get TikTok to be sold to an American company. Why would they want that? And to me, it was interesting that nobody mentioned at that point that we already know American companies that have taken our data, right? So it seems to me that, I don't want to sound like too anti-government, but the one reason that the government may want TikTok to be sold is to use TikTok to gather more information from citizens. But let
me just jump in real quick. Let me say something real quick. As a private investigator, we can get whatever we can get our hands on. And we don't have to always go through the court system to get it. When you're experienced, you can go, as long as it's legal, you can get to it. So it just, I'm not gonna tell you that. That's my training. I'm only, always remember, when I do it, it's only for official business.
Right, but
it's not for my personal business, but I just want you guys to understand, you're saying the government this, the government that. You're here now because the police do what they want to do.
Right.
They don't follow none of the stuff that they're teaching you. They're teaching you to understand it, but the police don't even follow it.
Right, but my larger point is that we think that the situation is this, and that you are using it for a specific purpose. Whatever we decide about technology, we have to be aware of the relationship of those companies to government entities like the police and also the federal government.
Yes.
So that, and it hasn't been right. So it hasn't been decided how. So Google gets to decide by itself.
So
Facebook
what I
gets
would say is this Carpenter decision is a big step in one direction, which is that This was not about the government gathering information. It was about when you walk around, your cell phone is creating a record of everywhere you've been.
Bingo.
Right? So this was Sprint and Metro PCS data. The government went to them with a subpoena or an order under the Stored Communications Act and got that data from Metro PCS and Sprint. And the defendant said, you needed a search warrant under the Fourth Amendment. The traditional rule is, no, you don't, because this is data held by the company. It's not, I'm not getting your data, I'm getting data held by the company. Happens to be about you. And the US Supreme Court said, big ruling, that is protected by the Fourth Amendment, even though it was a private company that collected it. So a lot of companies now these days, they still don't know exactly what it's going to apply to and what it doesn't apply to. But Google, all the information they have about you, Apple, all the information they have about you, they're increasingly, due to this decision, taking the view that this, if it's really detailed, if it's private, it's probably protected by the Fourth Amendment, and we should probably require a search warrant, not just a subpoena, not just something lesser, but a search warrant to be able to turn this over. So this is an important decision, a very big decision on new technology heading in that direction.
So would that same decision be relevant as far as DNA and everything that's been going on with ancestry and how the government has, been using?
Yes, it is relevant to that. Yes, it is. It could be an argument that they should get a search warrant to be able to get that information about ancestry or whatever. Yeah. Okay, let's talk briefly about the First Amendment. This is also me. We got to try to keep moving a little bit because we're running out of time. I'm going to try to just touch on a few key things here, and then I'm going to turn the mic over to my friends, right? So a couple things that I just want to mention briefly about the First Amendment, right?
Hey, yo, can we keep the side conversations down?
All right.
Please.
Citizen recording of the police, policing protests, and First Amendment rights of individual police officers. Let me just say a few things about those three things. Do citizens have a First Amendment right to record audio of the police in public? And the answer is probably yes, okay? The US Supreme Court has not ruled on this yet, but the federal circuit courts, one step down from the US Supreme Court, most of them so far has said yes. The answer to that is yes. They do. It can be subject to reasonable restrictions. The Sixth Circuit here in Ohio has not actually decided this yet, but in general, the answer is yes. There can be reasonable restrictions of the citizens have a First Amendment right to record the police in public, is what it looks like so far. Okay, so that's one important issue. Policing protests, okay? What are some of the rules under the First Amendment that are related to that? Traditional First Amendment law talks a lot about different types of forums, okay? And so you're down in Public Square in Cleveland. That is a traditional public forum. The purpose of that forum is for people to be able to be there, say what they want, do what they want within the bounds of the law, right? In a traditional public forum, the police are not, or the city is not permitted to even require a permit. You want to go down there, hold a sign, protest, whatever it is you want to protest, TikTok or anything else. You don't need to get a permit to do that, and the city cannot require you to do that. If you and 500 of your best friends want to go down there, then they can require a permit, okay? They can't evaluate the content of your protest. They can't say, we're going to give you a permit if you protest this, but not this. But because of the size of that group, they can require a permit, okay? So, or if you're going to, your protest is large enough that it's going to obstruct vehicle or pedestrian traffic, they can require a permit for that. There's also a First Amendment principle that during a lawful protest, police should not be gathering information even about individuals or demographic information who is attending this protest. Police are obviously allowed to be present, allowed to make sure people are, not burning buildings and whatever. But gathering information because you're here at this kind of protest, we're going to keep track of that information. That creates a chilling effect on your First Amendment right to protest and to associate with whatever cause you would associate with. First Amendment rights of individual police officers. Police officers like the rest of us post stuff on social media, right? And they get in trouble for it, like the rest of us too, right? So all public employees, including police officers, have a First Amendment right to speak on matters of public concern, subject to certain limitations. So So first of all, even when speaking on a matter of public concern, the state as an employer has certain legitimate rights the courts have held, okay? So a police officer talking about, the mayor's new policy on X, right? That is a matter of public concern. So there is some First Amendment protection there, but that is going to be weighed against the interest of the state as an employer in promoting the efficiency of the public services it performs. And so there's not an easy answer to that, right? Is the officer allowed to make that comment or are they not? It's going to be weighed against the state interest as an employer in trying to maintain speech that addresses solely personal matters are not protected by the First Amendment. It may or may not be a reason to discipline them under the relevant disciplinary rules of the police department, but it's not a First Amendment issue if it doesn't involve a matter of public concern. When police can potentially be disciplined even for off-duty speech if it undermines the mission of the police department. Here's an example from a case out of the Second Circuit, which is in New York, Pappas versus Giuliani back in 2002. The Second Circuit Court of Appeals, so the Supreme Court has not really addressed this yet. Police officer, the court held, could be fired for anonymously posting racist and anti-Semitic materials online. And this is kind of a long quote for a PowerPoint, right? But it talks about how that kind of information online, when we're thinking about the police as an employer and their mission, can undermine their mission, right? It can, a police officer making those kind of comments, even anonymously, right, can undermine, people find out it's a police officer. Members of minority groups will be less likely to report crimes, to offer their testimony as a witness, to trust the police to carry out their duties objectively, and so forth, right? And so the court said that was a lawful reason to discharge that officer. Interestingly, Pappas was a 2-1 decision. 3 judges on the Second Circuit Court of Appeals at the time, who took that case. 2 of them said, yes, that's okay. One of them dissented, and she argued, I'm not convinced that this is enough to justify firing this police officer, in particular because it was anonymous. So it's not, right? She wanted to put more of a burden on the state, on the police department to prove that people really were going to figure out who this was, what harm it was going to actually cause. And that judge on the Second Circuit who dissented was a woman named Sonia Sotomayor, who's gotten a promotion since then, right? So that's a really interesting case. So the U.S. Supreme Court has not ruled on this, but it's really interesting that one of the viewed as liberal justices on the U.S. Supreme Court had this as a lower court, and she took the view that she was going to put more of a burden on the police department to explain what the harm really was in a given case before just automatically saying, yes, you post something offensive online like that, you can be fired for it. So, interesting example. Okay, now we're going to go to Brady and Giglio, constitutional discovery obligations.
I just always think Giglio.
Gigolo? Yeah, Giglio, not Gigolo.
Different concept. Okay, so we're going to have a visual aid with this because, again, sometimes we are visual learners and you all have been reading a lot. So, as Jonathan had said before, Brady versus Giglio is constitutional discovery obligation. So discovery is information, just in case people aren't sure what discovery is. That's information for a case. Just kind of, you could talk about reports, phone calls, evidence. Typically, sometimes the way I'll hear discovery is that we file a motion under Criminal Rule 16. Oftentimes, the way that I hear that with my clients is, did you file my motion for discovery? Meaning, did you get the evidence within the case? So that's what I mean by discovery. We're going to discuss that. So Brady versus Maryland, the Brady rule. So that requires prosecutors to disclose material, exculpatory information in the government's position to the defense. So that would include any information favorable to the accused, which may reduce the defendant's potential sentence, go against the credibility of an unfavorable witness, or otherwise allow a jury to infer against the defendant's guilt. So good information, bad information. All right. Giglio. Okay, so that's almost an extension of the Brady rule. So think of Brady as exculpatory evidence. So good things, bad things about the case, good things that may help my client or help the defendant or not. And then Giglio extends that. So the Supreme Court extended the prosecution's obligation under Brady to the disclosure of impeachment evidence. So that mandated that prosecution should disclose any and all information that may be used to impeach the credibility of prosecution witness, including law enforcement. So I want to give you an example of impeachment information. That can include prior criminal records or other acts of misconduct, prosecution witness, or other prosecution witness, promises of leniency or immunity offered to prosecution witnesses. So typically, if I want to impeach the witness, that means I'm saying something or doing something to address their credibility, kind of to minimize their credibility or liability. Visual aid, the way that you could think of this as Brady, exculpatory evidence, it's a big circle. Giglio is within that. Okay. Brady list, Giglio list. So in terms of like, what does that mean? Like, give us an example. A list compiled usually by a prosecutor's office or police departments containing the names and details of law enforcement officers who have sustained incidents of untruthfulness, criminal convictions, candor, or some other type of issue placing their credibility into question. So oftentimes you'll get a packet. This goes along with the discovery, right? So I'll get the police reports, other things, and then I'll get a packet. They'll say, well, it can say Giglio information or Brady information. So some examples of that would be agreements exchanging testimony for money or favorable treatment. I've never seen this, but that's a possibility. Other conflicting statements made by the witnesses. Government witness had previously filed a false report. Information undermining the credibility of a witness identification of a defendant. So you'll get a number of reports. It's almost like you will get a packet of another case and you have to read through that carefully in terms of like, how was this case examined by this particular officer? What did he do wrong? What did he do? Well, yeah, what did he do wrong? So kind of it would include, those packets include the information that's listed right here. False reports made by the officer in other cases. Evidence of this is an example of a list. Evidence of substance abuse addiction. So overall, a Brady Giglio list, anything in the officer's background that reflects bias, untruthfulness, or criminal activity. Yes.
Is it illegal for them to like provide a bunch of information on like a situation so that then the information is hard to find? Like, could they be like, here's the entire file of, just
they give you like a bunch of information. Is it illegal? No. It's
is
just
that common?
Sure. But then it also like depends on the type of case you have. It may also depend on the tenure of that officer too. So I would just say whoever that defense attorney is, be prepared to look through all that information. So is it illegal? No. Does it happen? Sure. All right. Remedies for police misconduct. Was that me? Oh, yes, Ms. Bickerstaff, you had a question.
I was gonna say, sometimes, as I know as a PI, they don't like giving you that information either. Right. They'll give you the request, but a lot of times they take out stuff. They don't want you to have it.
Right.
The people like we gotta get it.
Right, because you can do your own independent investigation with that.
Right. They conveniently get rid of it.
Yes. So, so there, and I don't know if because I know we're moving on to the next section, but so we know that the police department and the prosecutor's office are required to keep a list of Brady, Giglio, potential issues. Yeah. And then, so is there any, because that's something that we're addressing, and we have a meeting about it on Monday, but what are the rules around, have there been any lawsuits or any rulings in other states around requirements for what should force someone to be on that type of list? Are there a lot of parameters? Because that seems pretty subjective of what could.
Right. I see what you're saying. Like, are there certain parameters? I mean, the law is, I like the fact that it's broad. So, I mean, the fact that it says just exculpatory evidence, but then also impeachment evidence, that covers a number of different things. So then the Brady list, I mean, again, anything in the background. So it's as expansive, I think, as you should let it be. But again, I think depending on the situation, depending on the history of that officer, or officers, however way you want to phrase it, I mean, you can also do your own independent investigation with that. I think as long as it aligns with the law, which is relatively, I don't want to call it broad, but broad enough to encompass a number of different things. It's not super specific, which I think is a good thing. Yes.
So I think the other bit of information that would be helpful is that we are now tasked by the charter amendment to keep that list.
Okay.
Could you just give us an idea of in Cleveland, in Ohio, in what manner does this list already exist? And what is the process of making that information public? And how would I go get that list? You know.
So I think the problem historically, this idea of a Brady list, is that police did not really think of this as an obligation that they had. They didn't keep a list. But if you read Brady and you think about it, you realize they need to keep a list.
Yes.
Because they need to disclose anything to the defense that is material and exculpatory. And how do they know, or someone in the department knows, that this officer has lied twice before in previous cases.
And that doesn't change.
And so 5 years from now, they might not be disclosing that information, and then eventually we realize, oh wait, that should have been disclosed. You as a city had to keep track of that because that is material exculpatory information.
They don't turn that list over.
Well, they don't. Often they don't keep a list. So we say, I mean, the Brady list is something that should be kept. And so the fact that it's your idea that you're.
Oh no, in the chart, it's part of the charter. So
that's great.
We just have to develop a process to get the information.
I think you're in new territory where some departments did a better job of keeping track of that information and disclosing it, and many did not. Many departments did not think about the idea that we have to keep track of when our officers have been untruthful, because that's something we're going to have to disclose in a future criminal case. They didn't think about that, and they haven't been doing that. So there's not a well-established procedure. Here's how you do it. Y'all are going to have to figure that out.
And just to keep it moving, because they're on a timeline here. We have on Monday at the Rules Committee, and of course all commissioners can come sit in to watch it or watch it as we broadcast it. We have a representative who manages the Brady from Cuyahoga County Prosecutor's Office coming to talk about what they do already. And we also have Safety Director Carrie Howard to come and talk about what they do internally, right? So we are charged with something new. We can expect some resistance to it. And in fact, it goes above what the law says, because we can even interpret it according to 115 and my read on 115, right, in our own way. So if they say this person does not make the prosecutor's cut, we could say, well, it makes our cut possibly and put it on there. So it's a little bit tricky if we go there. So that's why, we'll hear Monday and we'll strategize on this. But the goal is to get us working to our obligation of 115 as quickly as possible with as much knowledge about this as possible. So they're just touching on the foundation of it.
Okay, thank you.
Okay, real quickly here, the remedies. My colleagues have done a wonderful job of kind of describing how the Constitution kind of creates that box I previously talked about in terms of officer conduct. If they step outside that box in terms of violating both the constitutional rules, the policy rules, there are remedies. Within the first remedy would be a suppression of evidence in a criminal prosecution of the suspect or defendant. If there was a violation of the Constitution, it's not a dismissal of the case. This is an evidentia. It's called the exclusionary rule. It's a rule created by the Supreme Court that says you can proceed with the prosecution, but to the extent that you obtained information in violation of someone's rights, you can't use that in the prosecution. Oftentimes that could be game, set, and match. They can't proceed with the case, but it isn't necessarily a dismissal. But that's a judicial function to ensure compliance. Within the second component here, internal sanctions, that's the space in which you now operate in terms of being able, this is the violation of the police policies, that give rise to a suspension or a sanction that up to this point is ultimately been through the police, the chief to the mayor. Now you have the final authority. So we talked about your power, your authority. Now you operate a lot in terms of the sanction piece, the remedy piece, within this body. Civil liability is always for someone whose rights have been violated to take it into their own hands. File a lawsuit for a violation of the rights that occurred. I mean, stepping outside of the box arises to a constitutional right. Or you have the opportunity to do to take your own civil rights action. There's civil liability. Always keep in mind, though, I had referenced earlier, the power of the importance of the collective bargaining agreement. In many instances, with regard to civil liabilities, there's indemnification agreements. So while you're trying to aim the sanction directly at the officer, oftentimes that becomes a city obligation as well. Just keep that in the back of your mind, is the extent in which someone is can be held liable for as a remedy. In terms of some of the Cleta's presentation, you also see here on the civil side for violation, the wrongful conviction actions. That again is not that really with that a violation of those discovery rules. That it could rise to the level of a wrongful conviction. Again, it's not necessarily a dismissal. Typically, you get a new trial. You have an argument for a new trial. Sometimes the practical result is a dismissal, but the sanction, the remedy for a violation, oftentimes is a do-over. Then you have criminal prosecution of the police. We've seen both how that works or how oftentimes it doesn't. Keep in mind with regard to the criminal prosecution, we've had court remedy, we've had administrative remedy. Again, another example of court remedy. This criminal prosecution is often rooted in the remedy from the prosecutor's office. Whether to take a criminal action, that's within the discretion of the prosecutor when and how to proceed with a criminal charge. One of the things for you to look at is what the standards are that are being applied to pursue a criminal prosecution to hold an officer accountable for wrongdoing. Most cases within regard to the state system, it's a probable cause standard to move forward with the criminal prosecution. Oftentimes, though, the prosecutor will go forward with a higher standard, the standard where they believe that in order to initiate a prosecution, they need to have evidence that would support a finding of guilt beyond a reasonable doubt by a jury. So it's that level of standard you have to look at and see the effectiveness of the criminal prosecution piece, but it's ever present in terms of a remedy to hold accountability. And then another role where you have a significant role under the charter based on the community piece, your outreach, communication with the public, the court of public opinion. The transparency, bringing light to conduct, bringing light to the adherence to the law, and the power of public opinion to affect change is ever present. So these are several of the remedies that come from moving outside of the box that the law has created. Jonathan?
All right. Let's talk about Garrity. So the context here, we're talking about police statements. So now I'm talking about the universe where, let's say the police suspect, they get a report that a police officer has engaged in misconduct, and they want to talk to that officer, get a statement from the officer about what happened, okay? So the context here is that a public employer is investigating its own employees for potential misconduct. And the officer, we'll call him Officer Garrity from the case Garrity versus New Jersey, right? Officer Garrity knows when my superior comes and says, I need a statement for you about what happened on this date. If I say, no, I'm not going to provide a statement, I have to provide a statement. I could be disciplined through as not complying with my employment obligations if I don't give that statement. Because of that, the U.S. Supreme Court in Garrity held that that statement that the officer gives in the internal investigation is therefore a compelled statement under the Fifth Amendment. It is not a voluntary statement, it's compelled, because he had these threat of employment sanctions hanging over him when he gave that statement. Because it is a compelled statement, it cannot be used against him in a criminal prosecution. Okay? It's true of any public content. Yes. Yes. So, so the options, right, for the police department then is you can conduct an investigation of this misconduct and you can require your officer to answer the statement, to provide a statement, but you know then I am not going to be able to use that statement in a future criminal prosecution of this officer because it's a compelled statement. You're effectively granting them immunity on that statement. That statement cannot be used against them. Alternatively, there is such a thing as a Garrity waiver, which says, here you go, I'm presenting you this waiver. I'm telling you right now, you do not have to answer my questions. And if you don't, you're not going to suffer any adverse employment consequences. But if you want to speak with me, I would be happy to talk to you. Of course, the employee can then just say, okay, I don't want to talk to you. And you can't sanction them for not talking to you because you just told them you weren't going to. But if they provide a statement to you after they've been given a Garrity waiver, then that statement would be admissible in a criminal prosecution of them, okay? But that's the context. So,
okay. So here's an example just to apply what we've learned, because of course it's almost 1 o'clock. We have to have an example. An officer is summoned to their supervisor's office for questions. Having a reasonable belief that the questioning is an investigatory interview for the purpose of determining possible disciplinary action, the officer requests her union representative for the meeting. Hint, hint. Once the union representative arrives, the questioning begins. It becomes clear that the investigation involves potentially criminal misconduct. Therefore, the union representative and the officer secure an affirmation from the supervisor stating that the questioning is for disciplinary purposes only, that the employee's answers will not be used in a criminal proceeding, and that failure to answer will result in determination. Is the employee currently protected by their Garrity rights?
Yeah.
Yes.
Yeah.
Yes.
So if they give a statement there, that's fine.
Yeah.
But it cannot be used in a criminal prosecution against
Right.
them in the future.
Yeah.
So this is as you can see, a constant issue in the context of police who are investigating their own officers, and the police believe there may be a criminal violation here that we may want to prosecute this person in the future. The process of getting that statement presents a very challenging situation for the department.
Does it matter if the investigation is being done by a different police department?
Not if the employee kind of reasonably believes that failing to comply would result in adverse employment action. So you could have another department doing the investigation, but if I don't answer their questions, my department is going to discipline me. That means it's a compelled statement.
I would think you'd have to have a supervisor from the original department present from the other departments investigating to give them their Garrity. I don't think the other part I would think they would only investigate if it was a criminal matter. They wouldn't put Garrity on any officer from Cleveland.
Yeah, I mean, to try to give if you want to try to get a waiver, you mean?
No, not even with the waiver. I'm talking I wouldn't give a Garrity statement to somebody that's not my supervisor.
Oh, fair. Yeah, I believe it. The officer may not be willing to do that because they're like, I don't know what situation I'm in right
Your
here.
situation, if you had somebody else there, I mean, you might get a Shaker Heights shoot somebody in Cleveland, so you're going to want to get a Garrity statement from you. You would have no authority to give them any kind of Garrity. Their supervisor would have to be present, and then give them the Garrity as you taking their statement.
Okay. Yeah.
How about the union representative?
That's not really required by Garrity or anything. That's just under the collective bargaining agreement. They may have that right. I don't know. I'm not here telling you what the CBA tells you or doesn't require.
Well, I'm telling you,
I don't know the answer.
I went through it. Her daddy represented me.
Okay, there we go.
It was a dirty,
Let's keep it all in the family.
It was a dirty cop. The lawyer had me indicted, so I was posted as a private investigator. And I am. And I pulled his text messages because he was sleeping with victims in cases he was representing. So what they did was they had him talk and he was protected by Garrity. And Rufus said, Brenda, he's going to be protected by Garrity. Rufus made me go to the internal affairs because I didn't think they was going to do anything. He said, you got to go for the matter of formalities. So they protected him the whole 9 yards. Chura, the FOP was there to protect his supervisor because his supervisor was involved with it too. So the FOP was there to protect them, and the FOP is for the white shirts.
All right.
So y'all can Google that.
Okay, so Garrity.
So that's
For use in a criminal proceeding, does that include getting like probable cause or you like creating like search warrant? So like if officer makes a Garrity statement, that statement can't be used in court, but can it be used by an attorney to then request a search warrant to like get the officer's cell phone?
Yeah, I'm not 100% sure, but I think the answer is yes, probably. You could use a compelled statement to get a warrant. Yeah, so that's a good point. It's not for any purpose it can't be used, but can't be used against them in the criminal prosecution. Yeah, right, very specific.
So the Garrity rights, it's only for the compelled statement in this context. If the officer was interrogated in a different context in court, right, and the same information comes out, that's not, it's just because he gave it originally in his, I don't know if that's even.
Correct. So in other words, there wasn't an internal investigation. I mean, that's another option is don't do an internal investigation. Mm-hmm. Just indict the cop and try to get testimony at the criminal trial. Now, at the criminal trial, the cop can just choose not to testify under the Fifth Amendment.
It's to ensure the Fifth Amendment, right?
Yes, and that's just true for any person charged with a crime. Like, you don't have to testify at your own trial. We can't force you to. That would be compelled testimony.
In this case, they were just making sure that his Garrity rights were doubly protected by getting this affirmation. What was the purpose of the union representative doing that? Couldn't he have said, I don't want to answer right now? He's still protected by Garrity.
The point is under Garrity is that the police essentially are put in a choice situation where we either get to require the person to answer subject to employment consequences, or we get a statement that we might be able to use in court, but we can't get both. Because if the statement is, so that it's the department essentially has to make a choice. You've got to talk to us, and if you don't talk to us, you're going to be in trouble. That's fine. They can do that. They can't use that statement in court. Or alternatively, you can say, we want you to talk to us. You will face no disciplinary action if you don't talk to us. Here's that in writing. Then any statement will be able to be used in court. But of course, the one option is the cop will say, great, I'm not talking to you. And then you can't discipline them because you promised you wouldn't discipline them.
What if the officer wasn't also involved in the possible disciplinary matter?
Can I?
He could be disciplined?
I'll just say this is a major part of the consent decree. So the issue of Garrity comes up in the consent decree multiple times, right? And the misapplication of Garrity was specifically cited as one of the problems with internal investigations, right? So in the consent decree, they were saying, well, you're going to Garrity too fast, too quickly with your internal investigations. Therefore, we can't. It's destroying the chances of criminal prosecution. So that's one of the things that they're trying to fix with the consent decree is having a firm process in place. And one of the ways they're doing it is putting holds on the internal investigation when there's criminal complaints or criminal possibility. Therefore, the criminal investigation, and Jim, you could chime in. I think you left before they made some of the changes. But these were probably at the beginning or talked about at the beginning of your term. So the idea is if it's suspected criminal, let that play out and address it as a criminal issue first, kind of a hierarchy, right? And then we proceed with the administrative. And there are CBA technicalities there, which changes with each contract. So it is a complicated issue that I don't think we're going to dive into that deep today in the interest of time. But Jim, if you have anything to add to that.
Quite often if there was a police shooting we'd have, right when I was out there, there was the city prosecutor would respond. And he would decide whether the officer's gonna have to interview under Garrity or under Miranda. So if one officer shot and his partner didn't, we would interview the partner that didn't shoot under Garrity. And then we could maybe gather more information, then the prosecutor could decide whether, well, how it's gonna go with the other officer. Isn't there something though too, or if you interview somebody under Garrity, if their statement has to be truthful? I thought there was some, not, if you're not, you don't.
That they could be prosecuted for making a false
Yeah, right,
statement.
if it's well, no, if they're not truthful in their Garrity statement, then they could face criminal charges, I thought.
I'm not 100% sure on that. I mean, you are correct that the question of whether your statement can be used against you to prosecute you for the underlying conduct is different than whether you can be prosecuted for making a false statement. Those are different questions. I agree. So, but I'm not quite sure.
Yeah, during my time in Cleveland, the truthful element was part of the policy,
Right.
that it had to be truthful testimony that you gave. Now, that may have just been unique to Cleveland, but that was clearly, during your time, was clearly the policy.
Okay.
So we can move on.
Yeah, go ahead. One more.
I just was curious, so is it possible that could you use, is it potentially, could Garrity be used to sort of almost strategically to prevent criminal prosecution?
Yes, by the police?
Because if I just have if I'm compelled to give a statement and I choose to give that compelled statement, I could put everything that I'm guilty of in the statement. So if, no?
It protects your statement from being used against you.
So then could they?
But it doesn't prohibit you from being prosecuted for those crimes.
Okay, but they can't use the statement.
Correct.
To prosecute me. They would have to figure out another way to get whatever information they need.
There has to be a complete, there has to be a separation.
Separation.
Administrative and a criminal investigation.
Right. So they could not, for example, you admitted to a murder during your Garrity statement, and because you admitted to the murder, they were able to find where the weapon was. They're not going to be able to use that weapon because it was obtained from your Garrity statement. But if they separately investigate and they find apart from your statement, they find evidence of criminal conduct, they can use that evidence against you to prosecute you, but not the statement.
Right. I'm just thinking like in terms of like civil cases and criminal cases, like if I'm a civil case and I have to give statements in a civil case and that can't be then used against me in a criminal case, right?
In an ordinary context, you can refuse to answer in a civil case if you believe it's going to incriminate you in a criminal case. You can invoke your Fifth Amendment rights in the civil case because your statement would be used against you in the criminal case. Okay, let's talk about civil liability a little bit more and qualified immunity. I'm not going to go through all of this, but the basic right here is that there's a federal statute, 42 United States Code Section 1983. So you hear reference to sometimes civil rights lawsuits or sometimes 1983 lawsuits. That's not the year 1983. That's Title 1983 or Section 1983. Sometimes you hear that parlance. This is a 1983 case. And it's a federal statute saying that you can sue a state government employee who is acting under color of law for violating your constitutional rights, okay? That could be an unlawful search or seizure under the Fourth Amendment, or excessive force, or deliberate indifference to your medical needs, or a violation of your First Amendment rights, right? It could be any constitutional provision. This I'm going to try to cover quickly, but essentially, you cannot sue the state of Ohio, even though the state of Ohio was kind of the ultimate authority involved, right? Because states have what's known as sovereign immunity from lawsuits in federal court. If you sue the state of Ohio in federal court, the state will simply come in with a lawyer and say, we are immune from suit in federal court, and the federal court will say, correct, case dismissed. Doesn't matter what happened, what they did, whether it was lawful, not lawful, they are immune from suit in federal court, the end. Cities do not have state sovereign immunity, but they cannot be held liable on what's known as an ordinary respondeat superior liability. So what I mean by that is, ordinarily, if you're working for a company and you harm someone, the company can be held liable for that, right? A UPS driver hits you with the truck, you can sue the driver and you can sue UPS. And if the driver did something wrong, UPS is also going to be responsible for it because the principal is responsible for the liability that their agent caused. That is not true for cities, okay? So the officer violates the Constitution and harms someone, kills someone. The city cannot be sued simply because they are the ones employing the officer under Section 1983. They're immune from that. They can only be sued if the employee was acting pursuant to a policy of the department. So in other words, it was the department that decided the officer was going to do this. They did it. That violated the Constitution. Now the city can be held liable directly. That's hard to establish, but it can be established in some cases. You have an actual policy that violates the Fourth Amendment. Now you can hold the city liable directly.
So what if the employee violates the city's policy and then causes harm?
Correct. So then the city cannot be held responsible.
Only the employee.
You sue the employee individually, you sue the police officer. That's why most civil rights lawsuits are not filed against the city of Cleveland. They are filed against the named individual officers. Now, as Bob Triazzi told us, the city is going to indemnify the officer. So the city is going to pay the bill and they're going to pay for the lawyers as well. But that's just because they've decided to do that on the back end or under the collective bargaining agreement. It's not required by the Constitution or something, right? So it's a weird scenario where you can't sue the city, probably. You can sue the individual officers, but the city is going to be defending the suit and paying the bill at the end. That's the convoluted setup here.
Can you sue the city if like an officer has a pattern of behavior and action wasn't taken against the officer and then
Yes.
So that could be negligent. Right?
It can't be, negligence is not enough, but sort of a deliberate, a thing that rises to the level of like, this is our practice, right? We know that this officer is constantly using excessive force. We are aware of that. We continue to not do anything about that. That could be a basis for direct liability for the city. That's correct. It's difficult to prove that that's what's happening, but in theory, yes.
What defines municipal policy? Is it written policies or could it be the at the directive of a supervising or a higher ranking officer?
Good. It could be a policy or practice. And so it could be a written policy. It could be instruction of a supervisor. It could be, like your example, is a practice, a thing that the city knows is happening and keeps letting happen. You know, the more that you're trying to establish a practice, you can use that. It's just difficult to prove in court. You have to have a lot of evidence to show that here are 5 prior examples where we knew this happened and we didn't do anything about it. It's hard to get that evidence, but if you have it, then fine, you can establish that. But again, even if you can't do that, people typically are suing the officers individually under Section 1983. That is where they don't have sovereign immunity, but that is where they have what's known as qualified immunity, a phrase you've heard a lot, right? And qualified immunity is the principle that individual officers, when they are sued for violating somebody's constitutional rights, cannot be held liable unless they violated a clearly established right. Okay? So this puts courts in the weird territory of saying, okay, it looks like what the officer did here violated the Constitution, but it wasn't clearly established by prior case law that that exact thing violated the Constitution. So therefore, the officer is protected by qualified immunity, the plaintiff loses, right? The no liability here. So it's a doctrine that basically shields officers even when they violate the Constitution, unless that violation is a violation of a clearly established right. A lot of the problem with qualified immunity are you can look at examples of cases where courts have said there's no clearly established right here. Some of them, to many people, appear to be fairly egregious. Like, are you kidding me? This is obvious. So a recent Ninth Circuit case where the plaintiff alleged that the police stole $275,000 in cash and rare coins while executing a search warrant. Not that they seized it lawfully under the warrant and returned it to the, evidence locker, but that they just stole it. And the Ninth Circuit said, even assuming that is true, there is no clearly established law that that is unconstitutional. And so they dismissed the case under qualified immunity. I mean, that's crazy, right? Like, of course we know that's not lawful under the Constitution. but that's just a recent case from a couple of years ago. So these are part of the reason that some people have objections to qualified immunity. One is to just the concept, but two, believing that courts are applying the doctrine in a way that's, bizarre and out of line with ordinary expectations and common sense. Yes.
So I guess what I'm confused about is theft is a clearly established law.
Right, but not a constitutional violation.
So what are the things that are generally clear constitutional violations
So
under qualified?
part of the problem here is how specific a court is going to require it to be. So, for example, it is clearly established that the police are not allowed to use excessive force when arresting a suspect. But the entire issue is, well, what does that mean in a particular situation? So you look at a particular scenario, everyone is going to be a little bit different. And unless an officer does something that it's clear from prior case law, you cannot do that specific thing, then a court might say, well, we think you did use excessive force here, but we're not aware of prior cases in our jurisdiction that says you can't do that specific type of excessive force, and therefore you're entitled to qualified immunity.
What about sexual assault cases? Is that impacted under qualified immunity?
Good question. I think that in general, sexual assault, a court would say no qualified immunity. Like if you can prove an officer sexually assaulted a suspect or something, I don't think the officer would obtain qualified immunity there. But there are crazy cases out there. This is a crazy case. So, okay. So, yeah.
I have a question. So there are efforts right now, I think, to petition efforts to get rid of qualified immunity
Yes.
in the state of Ohio.
Yes.
What impact does it have? Because qualified immunity is actually, it's not like a statute, it's a legal opinion from the Supreme Court.
Correct.
So, and also, could you explain what remedies are available to this plaintiff? Because qualified immunity is for civil cases?
Yes.
Okay. So what is available to this plaintiff at this point?
So, as Bob was telling us, there are a variety of types of remedies for police misconduct. I'm trying to get back to remedies. Where is that? There we go. Right. For someone who, let's say, suffered excessive force from the police, if they're prosecuted in a criminal case, they could try to get the evidence suppressed if that violated the Fourth Amendment. But in many of those cases, they're not being prosecuted. They just suffered from excessive force. So that remedy doesn't help them. Mm-hmm. They can pursue internal department sanctions that, sometimes that's effective and sometimes it's not. Mm-hmm. It's not going to get them any compensation. It might get the officer disciplined, right? Civil liability is them being able to get compensated for their harms, and that's Section 1983, right, that we were just talking about it. You can ask the prosecutor to prosecute your police officer because you think they violated a criminal law, but that's not the same thing as, they violated my constitutional rights. You'd have to find a Ohio state criminal statute that they violated and decide that they didn't have any applicable defenses, and that's just a separate, right? It's not the same thing. You violated my constitutional rights, it must mean you committed a crime. That's not the same thing. So for getting money from the police, that's your option, is civil liability, right? Getting a 1983 case.
Except in that case, when the officer stole his coins.
Right. They're
So
not
there's
getting
no
that money
remedy
back.
there.
No.
And then also, so if
again, in that unique case, you're trying to get items back that you say the police stole. It's possible that through the internal disciplinary process, maybe you could get it that way. But you're not going to get like a money damages award through the internal disciplinary process. You're not going to say, okay, you were harmed, we're going to award you $100,000. That's not going to happen through internal discipline.
So what is?
Was there any kind of criminal investigation in that case?
I don't know, actually. I read the Ninth Circuit qualified immunity case, but you're right. That seems like an obvious example where you might have a criminal prosecution, but I just don't know the answer.
So to come back to my other question, if they somehow manage to get rid of qualified immunity through referendum in Ohio, what does that mean for the police officers in Ohio? It's still, the federal law would still apply?
No, if qualified immunity were, I think at the state level, it would just mean you did not have qualified immunity if you were sued in state court. Mm-hmm. There would need to be a change at the federal level by Congress to repeal qualified immunity at the federal level. So if you sued somebody in federal court, you would still have qualified immunity unless that were removed at the federal level.
Okay. All right.
Okay. All right. I've got to run. We have a little bit more material here. And we're talking about subpoenas.
Yeah.
All right.
This would be pretty straightforward. Thank you. Thank you, Jonathan. Yes, thank you, Jonathan.
Sorry for a million questions. No, this is what we're here for.
Subpoenas. So I believe you all do have subpoena power. An order issued by the court or government agency. Subpoenas are pretty straightforward. Requires you to appear at a certain place, time, date to testify, or either to present evidence or present documents, excuse me, or bring in physical evidence. So kind of like, as I said, here are some examples could be subpoena to request CFS records or phone records. So Children and Family Services. What happens if you don't respond to a subpoena, aka don't show up or don't do what's required? It is punishable as contempt by either the court or agency issuing the subpoena. In other words, the agency or court may issue a warrant for your arrest, or you could be charged with contempt of court. Is there a different subpoena power for officers than civilians? It depends, as my favorite lawyer answer. I just have seen it applied differently at the discretion of the judge. So that's the only reason why I say that. If an officer does not show up for a hearing, I've seen judges upset. I've seen judges be like, okay, well, we're going to dismiss the case. So I've seen various things. So that's why I said it depends. Versus like if a witness doesn't show up, okay, either we're going to continue the matter, which could be an option for both, or either there's going to be a warrant out for the person's arrest. That could oftentimes be based off of what the prosecutor wants to do in the case. So it depends. This was just a picture of an example. If no one has seen a subpoena, this is a sample subpoena just from the Court of Common Pleas for Juvenile Court. So just explaining the case number, obviously it will look different, a bit different for you all, and just for you all to see the structure of it. So telling you where to go, what time, what you're willing to produce, there's a signature, and then the rules of, well, this is juvenile procedure, which is a bit different. So pretty straightforward.
Do you have to specify what you will be asked about, or?
On here, you should be. We're not going to be specific details. I mean, they talk about the case. And so just here to testify as a witness about the case. So, I mean, not specific questions or subject matters. I wouldn't necessarily put that on the subpoena because that's filed with the court clerk. So, yeah. Public hearings, Bob, I think this was you.
Oftentimes, government agencies take the show on the road. Public hearings, mostly, for two essential purposes. One is to share information, push out information that you think is important, for public consumption. So you're out of this room and into the public. Or oftentimes, government agencies use the public hearing to acquire information, get testimony from the members of the community to help inform your decision making. Important things to consider on the public hearings is that, much like you do here, the full compliance with the open meetings law is a requirement. Where it really comes into, you just need to pay attention to is the notice requirements. How do you push that information out into the community that there is going to be a public hearing, your media contacts, your public notice that you would typically do on for any open meeting, particularly in the public sense, as that needs special attention. So that's the one law you need to pay attention to, and then the other law to pay attention to is in the public is making sure that you have compliance with accessibility issues, compliance with ADA, making sure that your physical setting complies with the ability to equally access the meeting.
Not just with the green belt.
Exactly. So that's where the equipment piece comes in. That this is all to make sure that you're complying with ADA. One of the interesting areas that given the diversity of our community, how does language fit into this? Interpretive services. It's part of your deliberation here is making sure that you have all of the necessary equipment, the physical space, be in full compliance with the ADA. And then just from a practical standpoint, making sure that you go in, it actually flips back to your notice requirements. What the purpose of your meeting is, what precisely it is that you're bringing into the public realm. Again, whether or not this is going to be more informational distribution, informational gathering, what your expectations of the public might be. Always consider your own individual roles as either being listeners or even being able to pass along information, making sure that you have a set program. If it involves citizen participation, what does that mean? Limitation of time, however it is that you decide, the flexibility that you have. The important thing is making sure the public is aware of that. Whatever rules, in terms of constraining their ability to participate, full disclosure would be important. And then particularly toward the effort of, if the role here is to take in information, how do you go about collecting and recording the information that you're getting? What is your process in place to make sure, whether it be, oftentimes I remember with some of our congressional hearings I was involved in, you had court reporters, or now you had audio recording. However it is that you decide, is just an important factor, in making sure that you accurately capture the information that you're going to use for official business. Okay.
All right, I think that concludes the presentation from the CSU staff. I want to thank them for spending Saturday morning with us. And they did that on the fly. I mean, we started this conversation about bringing them here. Within several weeks, they were able to come up with this great content and hit all these topics. So thank you very much. We really appreciate you. And the contact information will get you for everybody if there's any follow-ups or any additional questions as you come along. And I already sent the PowerPoint out. I don't want to keep you too much longer, but I have a few items that I'd like to cover while I have you all here. First, just some things based on the presentation you saw. The Dean Fisher's Reflections video is on our CPC site, so I will send a link out to that so you don't have to go searching madly in Google for that. I will also get you the Louisville DOJ findings. I've seen the letter. I didn't want it to distract us from our own work, but it'll give you a perspective, and you have a lot to read. This is a lot more to read if you dig into other cities' findings, but I will get that out to you. Anything you want printed, just make a request. I try, I don't overprint, but you have mailboxes there, so if you send me, they're up in the front when you come in. There's mailboxes there, and so if you need anything, we'll put it in your box for whenever you can pick it up. You just got to give me a note. As far as the police technology piece, so we've only touched on that a little bit, and this is going to be a big part of your work over the next 2 or 4 years, however long you're here. It's not new work for the CPC. One of our main pieces of work in 2022 was an actual document. We worked with Brian Ray at CSU, who's kind of an expert on surveillance and policing technology locally, as well as people from all over the country. We had a working group on this, and we produced a paper about Cleveland Division of Police's emerging surveillance technology, including ShotSpotter and other tools. They want to move to drones and things of that nature. But in our opinion, they're behind on the policy work. So they're putting the tools out there before they have concrete protective policy in place. That generally summarizes what we found. There are good policies out there in the world already, particularly in places like Oakland, where they have a whole separate privacy commission about it. Unfortunately, the city never officially responded to our recommendations and our points of concern. So it's kind of an open-ended thing for us to pursue that again when the time arises. But we do know they're expanding ShotSpotter. We do know they're expanding the camera programs. We do know that they have capabilities that are growing in that space, including the ability to plug in AI at any moment, at any time. They're also using automated license plate readers and deploying them all over the city, which is another major point of concern because they don't belong to City of Cleveland. So they're using other people's technology, which also gives them a tool to use, right, without having the accountability because it's not even ours, right? So there's a whole lot of issues there for us to unpack, and I think we can do that through the policy committee in the future, or set up a subgroup to follow up on this at any given point. But we do have work on that, and it is in your enormous binder somewhere in the depth. So check that. And if you'd like me to resend it, I can. I already mentioned Brady. Giglio is on Monday. A little deeper dive into that. Hopefully you can attend. If not, we'll have it recorded. Collective bargaining agreement was not part of today's structure. We are working with some of the city law departments who are exclusively in that space and deal with negotiating with the unions to come talk about the specific contracts, the labor law in more detail. So that is maybe going to happen on 4/12. We're working on that now. That will be part of the training of our regularly scheduled public meeting. And that's good because it's a significant area of public concern. So I think having the public be able to listen in on the labor law stuff. So we're working on covering that part. It was part of our legal block, but we just had a lot to bite off in one shot here. So the last thing I want to talk about is many of you attended the status conference report at the court, and I'm sure you have a lot of questions about it. And there's a lot to unpack. I do have a suggestion that those of you who attended might want to pick a presenter and kind of go over, your findings publicly at our next meeting. If you so choose, you could put that on the agenda. Someone who was there who can speak on what they saw and present that to the public. I think that's something you might want to consider amongst you who did attend. So that's another part, which I'll get to here. So monitor appearances are very structured. So the monitor has rules they have to follow in order to do an appearance. They are mandated to come before us at some point in the near future, and it's in the consent decree. They have to appear at a CPC meeting to discuss this, right? So we will set a date for them to do that. There's usually a significant period after they come out before they do that, maybe around 45 days to 60 days sometimes before we actually get to that. And there's a process we go through. I will reach out to them because I have several other issues I have to speak to them about. And we'll pinpoint a more specific time, but I'm guessing it probably won't happen until early May. That might be one of our agenda items at a public meeting, or we'll have a special meeting just for this, which we've done in the past. It's usually one of our highest attended meetings when the monitor comes and speaks about a report. So, but it is a mandate that we do that. They know that, and they will. It's just a matter of picking a date. They won't resist doing that. But in the interim, I still recommend you just give your viewpoint to the public of what you saw there, if you so choose. And one thing that I will say happened for those of you who weren't there because it wasn't broadcast is I did send out the semi-annual report. It's a heavy read. I haven't even gotten all the way through it yet. The main takeaway is they really are honing in on internal investigations and accountability, right? So the purpose of this meeting really was a lot of focus on OPS operations, CPRB operations, internal affairs operations, all of which are slipping backwards or never have been compliant with consent decree. So significant accountability issues, significant concerns is the word the monitoring team used about those specific areas. And then when it comes to us, you'll notice when Dr. Anderson was here at orientation, right? She handed out a piece of paper, which was also in your thing, in the orientation packet, was our specific section of the CPC, our compliance, right? We have to do things to help get this consent decree out of here, and this is on us. So we have paragraphs in here that we have to be compliant with. And when you open this up, you will see that we are now out of compliance for almost every single one. And the way the monitor explained this is twofold. One, you guys are new, right? And there's been a significant time period between when the last commission was here and when you came. So what the monitor said is you guys have to do your own work to get back in compliance, basically.
Can we give Delonte, your props? Because he explained that very well in your presentation about the CPC at the court session on Thursday too. In terms of when the last commission met and when we were on board. And you also acknowledged that we are out here trying to gain all of this knowledge, So I thought that was a good thing. I just wanted to say thank you. And you spoke, you were so articulate. Some people you can barely understand what they said.
I know.
But you were out there and you did it well. You represented. So thank you.
Good job, Delonte.
Thanks, Dante.
So yes, Delonte covered what we've done for the court since going back before you even here. So even including what the city had to do to get you here. So and I would second that. He did a great job in summarizing where we're at and where we plan to be by the next status conference. But don't fret when you see this. We know what we need to do to get here. The staff will help you get here. And we will develop a strategy for each one of these points to get back in compliant. Once the co-chairs are elected, we'll have that conversation on what we need to do that.
So my question is, how often are those conferences?
So they're supposed to be semi-annual, but it hasn't worked that way in years. It seems to be almost a once yearly conference these days. They may go back now that the new administration is here. In the beginning, it was like clockwork, twice, for every 6-month reporting period. But it seems like now the 12th semi-annual report is like, even though it's covering, remember these reports always cover a period of time that is roughly 6 months behind where we're at right now. So it's a snap. When you read this, keep in mind, there has been work done since this evaluation period. So you always have to keep that in the back of your mind that this is a little bit older window that you're looking in, and progress probably has been made in some of those areas. So you'll get the next snapshot. And I'm certain Delonte can comment, but I'm certain we'll probably go back with the new administration to closer, especially with the new monitoring team coming in, closer to a twice a year schedule like we used to do.
So yeah, the semi-annual period covers the calendar year, right? So from January 1 to June 31, and then from July 1 to 12/31. So those are the two periods, or the reporting periods. And then the conferences or the public hearing or for the status update to Judge Oliver, those will happen in September to cover the first period. So we did do that public hearing in September, and then the March one to cover the second reporting period. And so that will generally consistently happen twice a year in that regard.
Yeah. And my memory may be convoluted a little bit of how often they happen, but I know there's been a couple where it wasn't exactly on the perfect timeline, but especially during the transition between administrations. So we will get this in. The other thing I'll mention is every time a semi-annual comes out, we do a traditional thing, which we started several years ago, in the interest of the public, right? So when you read this, your head's going to want to explode trying to figure out where exactly are we, right? And we've heard that from the public for as long as I've been here, is how do you figure out how far we are, right? Because their rating system is based on an internal system between attorneys who are debating this subjectively of how far along we are on each one of these points in the monitoring team, right? So not really meant for public consumption. So what we do is we came up with a system where we put numbers on their compliance rating system, right? And then we do our math to find out exactly on a timeline that people can understand, or a percentage that people can understand, right, where we are. Now, what does that mean? Is it perfect? No, right? But it is effective because we often hear, and we have heard in the last several years since we started this, people now speak in percentages more. So public and other people have said, well, we're about 50% there, right? That comes from our quantification. Now, yes, it has been tremendously. So it's a good piece of work that has helped the public just get a picture. Now, keeping that in mind, we are going to do ours. It'll come out, right? Just like it always does. We don't put any opinion in here. We just put numbers on their system. So we never opine on anything. We just say, this is what the math says when you turn this into a numerical compliance system, right? Is it perfect? No, right? Again, it's a snapshot that's a little bit behind, right? So there is work always being done. Even the monitor said that at the status conference hearing, right? That it's always moving. So this is just a window in that one period of time, right? But is it something that helps? Absolutely. So we plan on continuing to do that. It's been a turnkey thing for, I think, the last 4 of them, and it's been really well received by the public to at least have something more simple to look at that gives them a generalized number. Now, you don't have to get to 100% to get out of a consent decree, so that's the one caveat to it, right? It is not that simplistic. It's not like a linear scale where everything has to be in full compliance 100% to say this thing is good enough to be done. There's language in those last paragraphs, which I explained at the meeting, that are at the tail end of the consent decree that says specifically the way that a consent decree can end. And it doesn't say a number in there. It uses terms that can also be a little subjective.
Judge Oliver said in court, he was expecting 100% compliance from people. So he may have said that and then something else is there, but he did say he was expecting 100%.
And ultimately, he knows that he is the only person that can end the consent decree. So the city can say, we want to put a motion forward to end this thing. We think we're good enough. Even the DOJ could say, yeah, we think we're good enough. And the judge could say, well, I don't think you're good enough, right? Levante, that's within the purview of the federal judge to decide. So we don't know when this will end. But again, expect this to come out soon. It's a turnkey thing that we always do, and it's really helpful to the public. So Ryan usually takes about a week and a half to just plug the numbers in. It also gives us a quick place to look to see what progress has been made. So he'll take it point by point and say, here's where we were last semi-annual, here's where we are now, where they don't do that in there. So you'd have to go back and look at the last 2 or 3. We have a consecutive thing where you can go, here's this one in a row, and see where you're at right now. So
yeah, going back, I think other people had this conversation on Thursday, but one of the representatives from the DOJ offered to come speak to us as well. So maybe that's something y'all could work on, or did you talk to them at all?
Yeah, we will invite the DOJ, but they do have an order that so the things have changed a little bit with this administration. The DOJ used to come here independently. Now I think they're following more guidelines that were set upon the court that said that the DOJ can't appear unless all parties are present. So that would mean the monitoring team and the city, correct, Delonte?
So yes, and if there's going to be communication that happens outside of the city presence, the city needs to agree to it. So basically, DOJ cannot just say, "Hey, come on, I'm coming over here. We're gonna have a meeting. We're gonna talk about stuff," and the law doesn't know about it.
Yeah,
right. That's what can't happen.
Yeah, and so that was a practice for the entire time until this administration. So we had the DOJ in our meetings often without other parties present. We had phone conversations with DOJ commissioners would call DOJ attorneys, and it's within their purview to do that. And if the court agreed, then it does limit how we can interact with the DOJ.
And they have reached out to request that, and we have no issue with allowing that to happen. So don't expect the city to be an impediment to your engagement with DOJ.
All right. So that's my quick coverage of I think the things that are on my mind. Are there any other questions before we get our? Let's turn out to be a beautiful windy Saturday back here. All right. Oh.
For the commission, so I kind of briefly mentioned this in the commission meeting, but I did attend the MRAC meeting a couple weeks ago, and the person who is facilitating asked if I could meet with them. I just want to make sure that's okay with the group if I meet with them and then report back.
Sure.
That show?
Okay, cool. All right, good. All right. Well, we're good to go. There's no adjournment today. It's just this was a training. And Delonte.
Just one point too. And Chandra just reminded me with the MRAC piece. Just for future reference or just for general reference, with respect to CPRB and OPS, CPRB, just make sure that if there's requests for information, there's requests for just communication, that go through their chair, Michael Hess, and then specifically with OPS, communication, invites, requests for information should go through their administrator, Jonathan Cutnick, not through any of the investigators, not through any of their staff. So I just want to make sure that is clear, because there's been things that the administrator was not aware of that was happening amongst other parties. So I just want to make sure that hierarchy is clear, so that we don't create issues.
He's the administrator right now.
Yes.
Not the one that's not coming in.
And just to add to that, that's in the rules for how we formally request information, because it does get a little out of control. Most times in the past, and we did have a firm commitment to this, that if you need data or information from any city department, it goes through here for the purposes of tracking. We can put a timeline on it. We know what's asked for in a big picture thing, right? And it doesn't confuse, because one commission already asked for something and no one else knows it. And then 5 months later, someone asked for the same thing. Then I get a call and they're like, what's going on over here? what are you guys doing? We don't even know who's asking for what. So it has been a go through with staff to ask for, formally anything or information. Now, to add to what Delonte said, you're human beings, right? And they're human beings. I don't think anyone has the authority to prevent conversations, right? So that's not something that we've ever prevented in the past, is to have relationships, independent relationships, right? Human information flows in that way all the time. But what we're saying here is, specifically, we can really harm a case, right, that we may see in the future, in my opinion, if we have too much communications between the investigators who are working on that case before it comes to us, right? So that's the due process thing too. I'm not saying it isn't going to happen because it's an imperfect world, but what I'm saying is be conscious of, those communications that involve open, active investigations that could potentially come to us.
Thank you. Yeah. Maybe before we walk out the door, I want to just acknowledge the work that Shelley put into the
Can you turn your mic on, Jim?
And also, you are my sister.
Oh, thank you.
Yeah,
I just wanted to acknowledge the work that Shelley and all the community partners put into the first trauma workshop for women. The numbers were not high, but the program was phenomenal. It was very informational, and I rather liked the smaller group because it gave every single person the opportunity to engage with the speaker and to ask questions. And I heard a lot of comments from people. By the time I got home, several people had even texted me. It was wonderful. Thank you. And Billy, the speaker, was just so knowledgeable and easy. I mean, her presentation was as appropriate for someone who was hearing it for the first time, as well as somebody who had been involved in trauma work for quite a while. So I just wanted a very diverse audience in terms of age and also in terms of race. I just think it was an excellent program. First time out the chute, a lot to look forward to with the successive programs. Thank you. Thank you.
Another thing I want to add to that is one thing that Shelley has done, which is so cool, is that everyone who attended the workshop is able to be seen for 12 therapy sessions, one per month, with one of the community partners, which is amazing because a lot of times when people do these kind of community outreach events, it can trigger a lot of things for people that can, but there isn't always necessarily access to support. And so I just think that was such a thoughtful thing. And I'm assuming that's probably going to happen for the other sessions as well. So just, also something to think about as you communicate with the public and encourage people to come.
Thank you.
Thank you.
All right, we're gonna go off live now, so we're officially concluded. Unless anyone else has anything else.
I know, it was great. It was